Catchment Operations. My name is Alan Cubit. I'm an Independent Hearings Commissioner from Dunedin, charged with hearing and determining this application. Just before we get into the procedural matters, I took quite a bit of time yesterday viewing the gates in question and the environment around that. Thankfully, I had some good weather, and it was about midday, so the tide was relatively high, so I got a good understanding of how it operated and the environment within which it operates, and also noted an awful lot of people readying their whitebait huts, because I think the season begins this weekend by the sound of it. So I might pop down there on Monday as well and see what's happening. With me today, you'll all know Catherine. Catherine is the consents coordinator. Any issues with procedural stuff, Catherine's the lady to deal with. She's just going to give us a brief health and safety overview in case we have a fire alarm. Thanks, Catherine. Oh, I should say phone's off too.
Thank you, Alan. Hi everyone, my name is Catherine, and today I'm just going to show you where the emergency exits are. The emergency exit is from this room are the door to my right and the double door through which you entered the meeting room. In the event of an emergency, please follow the guidance of staff. The toilet facility for male toilet facility in the foyer immediately just outside the council chamber, and female toilet facilities in the main foyer of the building. So all visitors are required to comply with all safety rules and health and safety legislation. If you hear a fire or emergency alarm, please leave the building at the closest exit at Southland and follow the advice of staff members. Thank you.
Thanks, Catherine. The only fire alarm I've ever had in a hearing was actually held in a fire station, so it worked out quite well. Also here with me today is Mr. Steve West. You'll know Steve as well. He's done the Section 42A report, which has been pre-circulated. We'll hear from Steve in due course. Catherine has also kindly set out a bit of a batting order that I think you've all received. I didn't have any input into that, but it looks fine by me, but I'm going to ask whether that suits the participants once we do our formal introductions. But I'll just add, I do have some questions for Mr. West of his report prior to kicking over to the applicant. Maybe at that point I might actually get you to introduce your team, Mr. Thompson, and just confirm what your batting order is and whether that timetable suits you.
Well, yes, thank you, Commissioner. So my name is Chris Thompson. I'm Council for Southland Regional Council, but more particularly the Catchment Management Division. So in terms of a batting order, I am intending on calling David Connor first, if we put a little number 1 next to his name on the list, and he's to my immediate left. Following Mr. Connor, I propose to call Mr. Young, for whom there wasn't enough room and is tucked away in the back somewhere. I'm giving you a wave. So if we put a number 2 next to his name. Third, Mr. Frisbee, who is 2 places along to my left. Then I propose to call Mr. Gardner, who's in a light brown jacket along the end there, followed by Ms. Drummond at number 5, and then finishing with my planning witness, Mr. McSorley, at 6. In terms of the procedure for today, there are two matters that I think it's probably appropriate to address now. Matter number 1 is probably the big, actually I'll go the other way around. I'm aware I've spoken to Mr. Pemberton for the Minister of Conservation or for Conservation, whichever it is, and I understand he has some time restrictions in terms of flights for him and his team. Now I just want to signal we're very happy to accommodate whatever he needs to get out of here on time.
Is Mr. Pemberton here?
Yes, he is, in the blue jacket.
Morning, Mr. Pemberton. So what sort of restrictions do you have time-wise?
So, yeah, explained it to Catherine, but myself and Ms. Sycamore will just need to depart at around 3:20 to get a flight back to Christchurch and then further north into Hamilton from the Sycamore City at 3:20. The other aspect, to Ms. Sycamore and Mr. Christie, who are here in person, Ms. Bowen is providing ecological evidence. She's unfortunately already had a previous commitment in Christchurch, so she, between 12 and 3 p.m, she has a room booked in the University of Canterbury where she'll be to provide her evidence. So that's why we've arranged, well, the tentative timetable is for it's the Director General of Conservation to be between 1 and 2 p.m. So just those are the two key constraints. One, we need to be out of here by 3:20, and just Ms. Bowen's only available 3:20.
Okay, so that current timetable is fine for you, because I was going to
That's
suggest
fine,
we
yes,
could
and-
swap with
Yeah,
Tamara. but-
Catherine's been very helpful in that regard.
Okay, great. Excellent. Thank you.
So that leads to the next point. What I've done is I've filed some evidence summaries plus some additional evidence that addresses the changes to the proposal that have been put on the table or will be put on the table today. Now, those summaries reflect a habit that I've formed over the years of preparing short summaries for hearings like this, but they're principally for the lay witnesses. It just gives them the opportunity to address you directly and ease into the hearing, which I've found tends to be more productive. So I would much appreciate it if my lay witnesses could read their summaries, which are all very short. I'm not as bothered about my experts. Both Mr. McSorley and Mr. Gardner haven't really done any additional evidence, but Ms. Drummond's additional comments on the proposal and how that addresses the various ecological effects, I think is probably worth going over, but it may be an exchange between yourself and her is a much more effective and more helpful way than her reading stuff to you anyway. And I know she's comfortable with that.
I think if your summaries are touching on, well, responding to the evidence that's come from the submitters, I'd like to hear that before any questions, because quite often my questions get answered in the summaries, because I have the same questions that submitters often have and they get picked up by the experts.
What I propose then is I'll invite my three lay witnesses to read their summaries. I'll invite Ms. Drummond to focus on the additional material justifying the amendments to the proposal, and perhaps we can be guided by you with Mr. Gardner and Mr. McSorley, the extent to which you wish to hear from them when we get closer to the time and know how we're tracking. The only other procedural matter I think I'll save to the end of my submissions that relates to conferencing, which you would have seen I've mentioned in my opening. But I think I'll give you my opening, and then perhaps we can address that and to the extent it's possible or necessary.
Well, I have had a quick read of your submissions, but not a detailed one. And I got halfway through Mr. Pemberton's submissions, and then my computer died on me, so I haven't completely read yours, sir. But so I do want to hear the legal submissions read out, because it sort of focuses the issues, however you want to do that. Okay, so is the 2 hours roughly okay for you, given that constraint? Because we can shorten up the lunch break if need be.
I think we should be okay. Look, my practice, which you might recall, is to not necessarily read the written submissions paragraph by paragraph. I think I can speak to them, and there may be areas where you wish me to pause and read them out. I'll just be guided by you. I mean, for instance, I don't think we need to read out stuff about the consents that are sought and all those sorts of things which have been well canvassed. So I hope not to take any longer than about 30 minutes, and I would expect my witnesses would be less than that, depending on questions, of course.
Thank you, Mr. Thompson. Mr. Pemberton, do you want to introduce your team and just add anything you need to procedurally?
as I've just said, Mr. Pemberton, Council for Director General of Conservation, and just to clear up for Mr. Thompson, just a small point, but the Minister for Conservation is involved in advocacy when it relates to the regional coastal plan, because the Minister has a role in signing off. Otherwise, the advocacy is always in the name of the Director General, so that's just a small thing. So I'll just refer to representing Doc here today. So I've got Ms. Sycamore, who's planning witness, Mr. Christie, who's provided lay evidence, is in relation to light weight compliance, and then Ms. Bowen, who's also who's a freshwater technical advisor, who'll be, well, I've already mentioned, be appearing.
Thank you.
I mean, so that's the summary, and I mean, I would like to make a few procedural points later, just in relation to the amended proposal that was received at 4 p.m. yesterday. But I can do that as part of my legal submission when we get going. So I suggest for now we just crack into it.
Yeah, okay, thank you. So submitter-wise, I have down like Tia Marama, I do not think are here. Oh, they are. Oh, yes. Hello. How are you, folks? We actually have a seat up here ready for you if you'd like to come up. Morning. Would you just like to introduce your team and confirm that the slot Catherine's allocated you folk is fine? She's got you down for 11 to 12.
Totai kātuka mihi ki te atua nana nei te tinutanga me te mutunga ngā mea katoa. Tōrua ki a koe Ellen. Te rangira o te rānei, mihi ana ki a koe. Huku no o whaitau, me rata mihi ki a koutou. Koe ko Stevie tuku ingoa. He kaipohu tūru kaupapa au ki te amarama tuku mahi. So I'm Stevie. Alongside Dean, we've provided a joint piece of water evidence. He's going to come in about 11 today, which I think is a dedicated time. He's got some other things on. Then we've got Margaret Frankson as a planner. I also have some comments like the department about the legal subs that come in next afternoon. But I can leave that for me.
Yes, thank you. Yes, thank you. So also today on my submitter list, I have Kerry Morton. Mr. Morton here. Welcome, Mr. Morton. So we've got you down from 2 to 2:30. You're fine with that time, so no constraints. Thank you. And Mr. Holmes.
Come later, apparently.
Yeah. So on his behalf, is he quite comfortable with that time frame?
I think he is at the moment.
Yeah. Okay. Thank you. Okay. Well, thank you for that. Unless there are any preliminary matters, I think most people know how these hearings work. The timetable sets out, applicant presents their case, then we go to submitters. Steve gets the opportunity to review his report, and then final right of reply rests with the applicant. No cross-examination, but what I do tend to encourage is sometimes a bit of dialogue around resolving issues if that's possible. I would have hoped that would have happened beforehand, given who the applicant is here. And I do have to express a bit of disappointment at how this has panned out. But I'm pretty sure your team's aware of that, Mr. Thompson. So I'm just going to go now to you, Steve. I just have a couple of quick questions in relation to your report. There'll be more later when you review your report. But the first question is around the applicant's plant. One of the key planks here is that the gates strategic infrastructure. And the evidence I read, particularly from Mr. Young, suggests that they don't really have much of an impact in flood control. They're actually designed to actually stop a natural process. So how do you, I've read your report obviously, you haven't really gone into the detail of that. So do you still accept that this is flood control infrastructure?
I've understood it always to be part of the Lower Matara flood control scheme. I do understand that the tide gates themselves are primarily about drainage, but I had previously understood them to be also deal with high tide effects on exacerbating flood effects. So perhaps that's a question for the applicant in terms of how they function. The RPS talks about drainage infrastructure maintained by the council as being critical infrastructure. I have no other view on that. That's the definition. I must accept that.
Yeah. So it's probably more of a drainage infrastructure work than a flood control, although it is part of a wider scheme. That is what I do want to hear from the applicant on, but that's sort of where you're sitting currently.
That's where I'm sitting at the moment,
Yeah.
yes.
So there is a policy framework that kind of supports that sort of infrastructure.
Yes. I haven't gone any deeper into the flood control aspects.
Yeah. Well, sort of again in relation to that, those structures, the legal environment, which I'm sure Mr. Thompson will talk about. We all understand how that works if something's not authorised. The question for me though is what sits in behind that. I imagine when these were first put in, this would have been a wet estuarine sort of piece of land. We don't probably know completely, but there is now pastoral, reasonably well drained pastoral land there. I'm assuming, well, I'm not assuming because I don't know, does that form part of the legal environment, or am I to take that legal environment behind those guys to be wet, sort of swampy land? Because it's the effect they've had, so how do I deal with that?
Sure. Look, my understanding is that the pastoral land is pastoral land. That's not the question.
It's how wet it is, I guess. Is it?
Yeah. It is awkward, I must admit. But my understanding is that the pastoral land is, well, it might be protected by the tide gates, isn't, and is affected by them to that degree. Would probably have to be considered as part of the environment.
Yeah.
Whereas the tide gates, the function on things like fish passage, you probably wouldn't have effects, but the gates themselves must be ignored, if that makes sense. I haven't expressed that very well. I'm sure the legal members will advise it better on that.
There's a policy, I think, in the RPS that you referred to on your page 44. I think it's the RL2 or something. It talks about lawfully established infrastructure. And we're just talking about legal environment, but this thing is lawfully established, but it's not legal. So it gets murky in that sense. But that policy, how do I view this in the context of that policy when it's actually not a legal structure, but it has been lawfully established? In there's probably a couple of ways you can go with that. It can sit there with the gates permanently open if consent was declined, or is the lawfully established bit operating, or?
I accept it's a difficult thing to address. I don't have an easy answer here. I'm just going to have to
That's a shame.
sort of work through it. Yes, it was lawfully established.
Yeah.
It is no longer authorised. I don't believe the policy goes as far as protecting it under the current circumstances. If that makes sense.
Yeah.
Because the authorisation has been lost, the past effects of installing it, perhaps just even the maintaining it, yes, the policy would probably be okay, but maintenance, being painting it or greasing the hinges, whatever. But in terms of making sure it stays there, I don't think the policy gives it that emphasis.
Yeah.
Once again,
Some of the applicants' evidence suggests that a consent would be required to remove the gates.
it's not the proposal in front of us,
No,
so I have not gone into that, but my preliminary view is there'll be disturbance with that as well. I would have to look at the rules around removal of structures. And generally, there is some permitted activities. I think the gates could be removed. The weir dam structure would need consent for removal.
yeah, well, that's kind of where I was going. If this was declined, you could require the gates to be removed, the structure could stay in place. So, and then it would be up to council how they dealt with the actual structure after that.
Sorry, is there a question on that, Alan?
Yeah, no, I'm just thinking out loud. Town has asked that they be removed and that the land behind it be rehabbed. Not, I guess where I'm getting to is I can't probably require that. As far as I can go, is actually decline the application and the gates sit there. But if it was declined, they have to be left open, I would have thought.
Okay, if the application is declined, the activities that are involved here, things like occupation as well as damming and diverting. So those activities would have to cease.
Yeah, so that means then they would have to be removed.
That would mean that, yes.
Yeah.
But it's not,
Including the
that's a consequence of your decision,
Yeah.
not the decision.
No, that's right. Yeah, yeah. I guess that's where I was trying to get to. There's a suggestion that removal required consent.
That may be the case, but that's not what we're dealing with today, as I understand it.
Okay, well, I'll probably have a few more questions around some of the policies once we get to your report later. Okay, thanks, Mr. West. We're in your hands now, Mr. Thompson.
Thank you. Just in terms of that last point that you were just discussing with Mr. West, I might be able to help. The removal of if we just focus on the weir, or the dam, whatever you want to call it, would still require a resource consent, but that doesn't mean it's lawful. So the point behind all that, well, there are 2 points. Number one, yes, you're right, you don't have jurisdiction to order its removal, but I don't think that matters very much, because at the end of the day, if the consent is not granted, the activity is unlawful, then it's for the Southland Regional Council to take whatever steps it needs to take in order to regularise the unlawful situation. So if it needs to apply for a consent before removing the weir, it would need to get on with applying for that consent post haste and do so. I think anything else would be an offence. And there's already, as I've said in my submissions and as in the evidence, there's an abatement notice that's already been served on the council with the Catchment division. So I think the 2 points are, number one, a consent would be required based on the advice from Mr. McSorley, but that's not really material for your decision. But you don't have power, and you shouldn't necessarily spend time thinking about any sort of orders or similar to require it to be removed. I think that's probably a blind alley for this process. As Mr. West put it, that's not what you're here to decide. So hopefully that's helpful.
Yeah, it's more in relation to some of the requests from submitters.
Yes.
I just think I can't go that as far as they are seeking.
That's right.
Yeah.
Okay. So if I begin my submissions, as I said, I think I will, at least until you direct me otherwise, sort of speak to them as opposed to read them out. But we can pause whenever you like. I'm doing this on an iPad, which is a little unusual. So I'll do my best.
It's the modern way, isn't it?
Well, it is apparently. Yes, it's just, I just haven't had time with my travel disruptions to quite get myself as organised as I would like. There you are. So I begin by introducing the proposal, and I'd quite like to just spend a minute up at that big A0 plan, which is attached to Mr. Connor's evidence. I'm not microphoned, am I? I'm not on a microphone?
No.
So I can wander around.
This picks it up.
Right, okay. So what we've got here is a map of the wider Titiroa catchment to orientate ourselves. It's kind of this part up here. Here's the stream or creek, stream rather, down here. The pink dot is the tide gates. That pink dot is the boundary of the CMA. Our tide gates are shown as the boundary of the CMA in the coastal plan. I think it's map 9B. To my left, we have the Matoda River, and down here is the, I think it's pronounced Toi Toi estuary. I believe that's Fort Rose, just at the bottom right-hand corner. We have additionally marked on the map something called the railway embankment up here in yellow, and that is an area, or rather a feature, that Mr. Frisbee and Mr. Young both refer to. And that's to do with the level of inundation one might expect with the gates removed. And at the very top, we've got something called the Titiroa cutoff. That's an artificial, I'm going to call it a channel, whether that's the right technical term or not, I'm not sure, but it's a channel between the Titiroa and the Matoda, and water's flowing that way to my left. So it is a connection between those two water bodies. I believe it was, and Mr. Young might be able to tell you more if it's of interest to you, but I believe it was built as part of flood protection works. In this blown up area here, you'll be familiar with that, having visited the site yesterday. Can I ask, were the gates closed when you were on your site visit?
Yeah, the gates, it was about midday, so probably high tide. So there was probably about that much difference between the water levels.
Okay.
Either side.
Yep. And so you can see here, this, you probably drove in along this road here, or at least you can.
I did actually, I went both ways.
Right. So if you come off the state highway, the bridge must be just here. You can drive along. You can actually drive over top of the weir quite happily. So that's the weir structure, and here is the channel that ducks around the side, and the gates are roughly there. I think those are all the features I wanted to point out, other than to note that these green lines are the various tile and mould, and red lines, the various tile and mould drains through there, which have been developed over the years. Now, these are the ones that council know about and council map. There may be more. This has been pulled off council's GIS. I don't think this is sophisticated enough to show you what's a tile, what's a mould, what's an open drain, but it gives you a pretty good idea of the very extensive network that's been developed.
Well, while you're up there,
yeah,
can you point out, I think it's in Mr. Gardner's evidence, the 9 hectares he thinks is most adversely affected, because it appeared to me in the report that the area shown was a lot bigger than 9 hectares.
Yeah, where would you say that would be, Matt? Easier to get him to do it.
Yeah.
It was up to about the railway bank. So the railway bank is here, so it was up to about.
Can you just sort of stand?
Sorry, it was definitely above that kink, I remember. So it was up to about here. I have made the note in my report that because we don't have channel survey of the inverts along there, it's an estimated depth of water, and some minor alterations to the channel depth actually would extend the water further up closer to the railway embankment.
Yeah, so the 9 hectares, though, it was a lot bigger than 9 hectares that I could see on your map, but was it narrow to around the channel?
Well, that's a good question. I'm going to recheck that 9 hectares. So that was a figure given to me by a staff member and calculated we had a polygon of the area which I
Yeah.
thought.
I'll find that because
And I'll quickly double check if that should be a, if I can get it in here, I can confirm that. I've got the file on my computer.
yeah.
That's it, yeah.
Now, that looks to be a greater area than 9
So
hectares.
that's up to, that's that kink which I was talking about,
Yeah.
which is up to about there. So it's that road. It was up to close to that, just downstream of that road.
Yeah, and the
crossing.
bottom bit is a fair way down, so that's
Bottom bit is-
way more than 9 hectares, isn't it?
I'll recalculate that right now.
Just from my untrained eye and having driven around it, because that's Fleming Road up the top, isn't it?
The road name's like.
Yeah, it is. It is.
Fleming Road up here, is it, Liz?
Yeah. Okay, thank you.
I don't know.
Steve's,
So I'll leave it to.
Yeah,
Mr.
I'll
Garner.
just reconfirm those numbers.
Yeah.
So the two other points, in terms of the area that Mr. Gardner has modelled, that's about inundation, and you've also got the effect in the drains. So the water could well push up into some of the higher drains anyway. So that's some of the subtleties of the model and how it's set up, and I'll come back to that in my submissions. The last thing to note are the private landholders, and again, other people are going to be better than me in showing where those are, but I think one of the blocks about it here is private land, and then one of the submitters opposing the application is over here somewhere. So this map, I found the red lines a little confusing. The red lines are not property boundaries or leaseholds or anything like that. Those are drains. We had one with various property boundaries over top of it. It was just a mess. And that felt a bit cleaner, like this is a bit more helpful. Yeah, if it looked like that, it's just hopeless in terms of sending being able to provide a nice clear picture.
Thank you.
So that largely deals with the first part of my submissions. I then go on to discuss the plans and the resource consents required through to about page 3. And there at page 3, I set out 6 issues that I extracted and summarised from Mr. West's report. And in an attempt to be helpful, I've put those in a table at the end of my submissions. And I just thought that might be a useful way to perhaps grab some of the issues that he had identified. Turning to then what I think are one of the more important things to deal with today is the amendments to the proposal. I'll wait to hear from others as to what they say about the timing of that. It's probably a good time to address 2 matters. Look, I am alert to the concern that you raised earlier about engagement and the fact that we have organisations that perhaps could be working a bit more cooperatively together somewhat at loggerheads and making it your problem. I appreciate that may frustrate you. The council's position is now set out pretty clearly, and it may frustrate others too, I should add. It's not just you. The council's position in respect of that engagement, particularly with its treaty partner, Ngāi Tahu, is set out in my submissions now. You will see that council acknowledges that the engagement was suboptimal. Mr. Connor's evidence addresses that. My own view is that's done now. And the more important thing from my perspective, and I believe I can speak for my client, is once this process is finished, and indeed for any future of these gates, that we do better going forward. And there are references in my submissions to that. So look, we're not trying to hide from those frustrations that others may feel. There are always two sides to every story, but we're not going to go down that path. We're going to just focus on the issues. The second point is the timing of the amendments to the proposal. Again, I'll wait to hear what others say, but I just observe that these sorts of projects, in my experience, often are quite flexible and they can change. They can even change during hearings. A lot of the real significant issues, we were actually assisted by particularly the ecological evidence from the Director General of Conservation, and that helped crystallise a number of these matters and lead to an amended proposal. You'll see what I say in I'll come to it in a minute, but I've learnt that the term fish-friendly gates is not something that can be applied to a thing. It's more a concept, and then the exact nature of the thing will depend on lots of different stuff. So the first point I make, and I'm at my 15 now, is firstly, and I come back to it in my submissions, Council remains open to exploring mitigations to address the concerns of Ngāi Tahu. There have been, as acknowledged by the evidence from the various Runanga representatives, engagement over the past little while to have a discussion. Unfortunately, we didn't manage to do that. And its position is what it is, but Council is still very much open to considering those matters. I considered but didn't discuss with anyone whether I would seek a Section 99A direction for some sort of mediation. I haven't done that. I don't know if it will be worthwhile or not, but there is a real interest from Council in having that further engagement if it can be accommodated. So what's being proposed now is an amendment to the proposal whereby and we're referring to it as a letterbox or a cat flap is another way I've heard it referred to, be installed into one of the three gates that are hung presently on site. What that letterbox or cat flap does is, it does what it says on the box. It's an ability for fish to pass through that cat flap and to provide fish passage upstream when the gates are otherwise closed. Now, one of the issues that the Regional Council is confronting, as in the Catchment Division of the Regional Council, was finding a solution that achieves its goals, which are to continue to control inundation above the gates, but at the same time trying to provide for that fish passage. Now, the thing about this letterbox type design is it gives us a lot of comfort that the effects upstream will not be significant in terms of inundation, whereas some sort of mechanism that holds the gates open for longer could well lead to inundation to a level that sort of makes the proposal, if not pointless, certainly doesn't achieve the goals that Council have. And that's why Mr. Gardner has modelled a little bit of extra time with the gates being open, an extra hour, I think, which is half an hour either side of the tide, and 2 hours, which is an hour either side. And that does show that there will continue to be effect if all three gates are open. So it's a modification to allow a little bit more water up, but to provide for that fish passage. And that might not be the end of it. The ecologists seem to agree that hinged gates are a good thing. And so one of the other parts of the proposal is we're asking for 10 years from the date of your decision for a term of the consent, and that's to allow for the various monitoring and capital works and other matters to be addressed over the term of the consent, but also have indicated through my legal submissions that during that time there are some conversations to be had with the community and stakeholders about the future of these gates. Now, I don't think it would be lawful for you to impose a condition requiring that, and I'm not offering that on behalf of my client. That's a Local Government Act thing. and that's consideration of the views of those who are affected by any decision. But council will need to do that going forward. So there's a link there to give the time between the term of the consent and the work that needs to be done. And I'm at about my paragraph 20 now. The other part of the proposal reflected now is a suite of monitoring conditions. Those monitoring conditions are matters largely raised by the Director General's ecologist, but not everything that she has requested by way of monitoring. Some of those matters were a little bit prohibitive, but where they were reasonable and provided some bang for buck, they have been incorporated. And they are now showing in the draft set of conditions attached to my evidence, and also attached to Mr. McSorley's summary. There's a subtle difference. Mr. McSorley's summary has a plan referenced in it, whereas the one attached to my submissions don't, but Mr. McSorley's is the most up-to-date version. The original proposal was for baffles to be installed for fish refuge. Again, in response to comments made by the ecologist for the Director General, Ms. Drummond's reconsidered how practical it would be to construct or install baffles, whatever the right word is, and is now proposing boulders. And they have some other advantages as well. Second to last, inanga habitat enhancement works are still proposed, and there is an attempt to provide a bit more clarity as to what exactly is proposed in Ms. Drummond's evidence. And then finally, there are two matters which are offered and put on the table cautiously, or rather the way I put them on the table is cautiously, because it's quite clear as a matter of law that it's not appropriate for you to consider in your decision the past behaviour of the applicant. You're entitled and should expect them to comply with the conditions you impose. However, there's a practical overlay here, and it goes to the matter we've already discussed, and the disappointment you expressed earlier. And the practicality is that we get it that there's probably some low trust at the moment, and we understand why that is. We've provided some explanations, but we're not attempting to make excuses. So there is within the monitoring conditions, they have been deliberately structured in a way that require pretty regular check-ins with council and delivery of monitoring results, and then a pretty what I think chunky review condition linked to any monitoring that comes out of the effectiveness of the cat flaps or the letterbox design with the fish passage. So those conditions are offered quite knowingly with those particular issues in mind. Moving on to matters, some of which you've addressed already, what I've tried to do in my submissions is to set out just a couple of areas of particular materiality when it comes to the law that I thought would be helpful regardless which way you ultimately decide this application to discussion in your decision. The first is retrospective consents. Nothing wrong with them is the short point. I think you probably know that. And just confirming that section 124 doesn't apply here due to the timing of the application. I do note in my paragraph 32, just a note that a number of the submitters have been quite critical of the application. That's their right. But that application was prepared by Mr. McSorley on an urgent basis, given some timing issues. And also I note that there was also a section 92 request, which was responded to promptly as well. You've asked about, and I'm now down at my 34, you've asked about the environment and what the environment should be. I think you've identified quite a material question. there are some authorities in here that address the issue of the status of the gates, and I think you're right, and I think Mr. West is right, and I suspect others as well, that given Section 124 and the fact that the consent has expired, you need to assess the environment as if they're not there. And I've cited Ngāti Rangi for that proposition. I think it's fair to acknowledge that the exception in Ngāti Rangi about fancifulness and unrealism or lack of realism is not so simple as to say they've been there for ages, so that makes the removal of them unrealistic. I think that's drawing too long a bow, so I'm not inviting you to go there. So you should assess the impacts on the environment as if the gates weren't there. They don't get any special treatment. I think, though, the question that you nailed or focused on a short while ago in terms of, well, what's the surrounding environment? I cite the well-known contact energy case, which was that geothermal energy case that came out of the Waikato. And I think that makes it pretty clear it's the environment at the time you make this decision. So it wouldn't be lawful, and you shouldn't imagine the environment as some sort of undefined, sort of pristine wetland or similar. It's a modified pastoral environment, and I think that's the wider environment you need to consider. And then I've expressed in I think it's my 42, just a word of caution that I'm not submitting that means you need to characterise the reversion back to wetland as an adverse effect of not granting an application. I don't think that's the right way to look at it. But you can, and we're inviting you to view the gates as contributing to shorthand pastoral agriculture. Now, there's a policy in the PSWLP which expresses that, and it doesn't say pastoral agriculture. And in fact, in the Aotearoa cases, the judge explicitly said, no, I'm not going to put that in, but that's all part of it. So it enables that activity. So moving on, next I touch on some of the reasons why we're here and the applicant's position. I note firstly what I've just touched on, which is the enabling of the use of the land in a way that's beneficial for the council catchment division, says the entire community, the wider Southland region. I think it's artificial to suggest that there's not a wider benefit, because everything sort of spiders through the entire region when it comes to those positive effects. And I note Mr. Frisbee talks about, excuse me, the early start's catching up on me. Mr. Frisbee talks about the people he employs, which is another positive effect that flows from these gates and the enabling of the pastoral agriculture in the immediate area. A point not picked up really, as far as I can tell, additionally, is Mr. Young's evidence that we expect the gates also have an effect on keeping water levels high below the bridge as well, which is an area of significant wetland habitat. And really important to highlight to you, on behalf of my client, there has been an awful lot of habitat enhancement and other conservation work undertaken by the council within this area, so within the Titiroa catchment. And a lot of that work has been assisted greatly by the lease income that's come in from this pastoral land, which are enabled by the gates. So I just don't want you to have the impression that this is a case of we have a whole lot of leases which we're leasing to farmers, and they're farming the land and we're not considering other things. There's in my submission, quite a responsible approach. So there's been quite a lot of land retired and repurposed and protected. In my 46, I just note that fish passage is not completely impeded, which I think is the impression that you could get from some of the submissions. Of course, the gates are open for half the day. We're not saying it's not an adverse effect. We're just saying that that needs to be noted as well. And finally, I've noted in 47 the whitebait fishery and the effect on inanga spawning. Moving now to 48 and cultural effects in the applicant's response. I've already sort of addressed thematically what I deal with in these sort of 7 or 8 or so paragraphs in terms of attempts to engage and a desire to do so going forward. At 51, I say the evidence, and there I'm referring to Ngārunanga's evidence, explains the relationship between Ngāi Tahu and water, and then it goes on to criticise the application starting point for not asking what a healthy state of each water body is. And I recall that, I mean, that's significant and it's not accepted for the record. If the answer to the question, what is a healthy state, is a stream with no gates, I mean, that, well, again, it's not accepted, but really shows the size of the challenge. And I say in my 52, there's no policy support for that position when the PSWLP is read as a whole, in the way East-West Link tells us to. At 53, I say this application has not fallen into the trap of assessing effects as being minor or less than minor from a Western scientific perspective. The difference between that and Ngāi Tahu conceptions of values are understood. That there is an impact on Māori is likewise accepted and understood, and the cultural effects are acknowledged. I submit, though, that a more appropriate understanding of the relationship set out in the PSWLP between cultural values, including Māori, and the sustainable use of resources, including the land, can be expressed in less binary terms than the idea of gates or no gates, which I say is that more appropriate understanding, I say, is reflected in the PSWLP, which, to quote Judge Borthwick, "Te mana o te wai is draped over like a korowai," or cloak, in expressing that paradigm shift we've talked about. I do want to read this for the record, even though I've already noted it, that Council would like to re-engage with Ngāi Tahu on its aspirations for the area, and these are my instructions to record this. Over the proposed term of the consent sought, it is clear that a longer-term decision-making must be done in partnership with Ngāi Tahu, like I'm told the Council has successfully done elsewhere in the region. Additionally, that longer-term approach must also consider the views of all of those potentially affected by decisions on the gates. And that sort of demonstrates why I ultimately decided not to seek a Section 99 A order and direction for mediation or similar. I think there's a whichever way this goes, there's a longer way, a bigger issue to deal with. Turning quickly to the model, Mr. Gardner's obviously got something he needs to check, but subject to that, I just wanted to explain to you the basis upon which the model has been presented. Possibly due to my own limitations, I always go back to the famous Professor Bock's comment, all models are wrong, but some are useful as reflecting their artificiality and the fact they always fall short of real life complexities. So the modelling done by Mr. Gardner is not the final say when it comes to the extent of inundation and what we might expect from removing the gates. It allows you to conclude in your decision that the removal of the gates will lead to an increase in the water table upstream, something a number of parties have addressed and criticised the application for not being clear on. And it shows that changing the amount of time the gates are open, some sort of weighted gate leaving it open longer for fish passage, is also going to have an effect, and that's because of the extensive mole and tile drain network. Mr. Gardner, as I said, can tell you more about this, and I've already noted that you've got the issue too to be alert to of water pushing up those drains as well. Then you have the evidence of Mr. Frisbee and Mr. Young, who say, well, we think there will be inundation all the way up to the railway embankment, which is a bit further up. And to the extent that anyone wishes to submit that that's an inconsistency, I say it's not, because the two can be reconciled on the basis that if you understand what models do and how they assist environmental decision making, there's room for both. So don't rely on the model as a representation of a natural system. That would be flawed. And it also shows the model is somewhat conservative in my view as well. Now, Sarah, I move now, and I'm mindful time's galloping along, perhaps predictably, but I move now into some discussions about policy settings. I am alert that you have spent, was it a year, talking about Te Mana o Te Wai for the proposed Otago regional policy statement, and
Probably closer to 2.
yeah, closer to 2, right? So
The only question I have for you around this though is
yeah,
the proposed Southland Land Water Plan.
Yeah.
Wasn't that developed under a previous iteration of the
well,
NPS?
it was a bit tricky by the time we kind of got to hearing.
Yeah.
I didn't appear on the, I don't know if Mr. Pemberton did, no. I might have been Penny, might have been, yeah, okay. So by the time I was involved, the new NPSFM was in play, and I did, Ms. Hicks, if she's here, might remember, was it number 2, tranche 2? Yeah, I did tranche 2, not for this client, for someone else, which is policies and rules. So it's a bit tricky. But I think you're right. I think the earlier versions may have been, but the key, and I had in my first draft of my submissions some wider comments. Now, sir, having appeared before you before, I decided not to put them in there because I suspect you may have found it a bit superfluous. But I will note that one of the things I've found really persuasive about Mana o Te Wai is a really good Waitangi Tribunal report, which, as I say, I didn't have in here. I forget the number, but it's a Waitangi Tribunal report which discusses how the NPSFM has developed over the years to get to a point where Mana o Te Wai is addressed in more than a way of just paying lip service, so the have regard and the like was inadequate. And we got to a point now where I think recognise and provide for was what the Waitangi Tribunal was saying you should do. Probably gone further now in the latest NPSFM, now we're giving effect to it. But that Mana o Te Wai notion was still pretty strong, even under the first Aotearoa decision.
So there's no material.
Well,
difference.
I don't think there is. Others might not. But I think this is a really good modern plan. Now, where we've got the issue here, and because I've focused on the PSWLP because I think that's quite important. But where we've got the issue here, I think, comes down to how you view and resolve the clash of values through the lens of the PSWLP, because I think we can be pretty confident, as I said, it's a good, modern, strong plan that I know Judge Borthwick spent a lot of time thinking about and drove everyone a little crazy in the first hearing, as I understand it, in terms of notions of plan architecture and other such things. But I think that was work that at the end of the day was actually very well. It was a good endeavour. So you've got a plan now which really sort of acknowledges and addresses those issues. Now, I say, fundamentally, sort of cutting to the chase, I say that when you apply the east-west type read the plan as a whole, which is not a new idea, you can see that it reflects the overall sustainable management purpose of the Act in this plan, and it recognises that in some circumstances, values will be affected, and you can still consent things in terms of the objective and policy framework. And what I do in my submissions is go through some of those objectives and policies. Now, I've then sort of applied partly, or I've also applied the Port Otago structured analysis, not because it directly applies here, because that's about clashes of policies, but I just think it's very useful. What it does is it reminds you that when you're undertaking this exercise, do it in a structured way, and sort of think very carefully about how the policies all sort of drop down and spit out the other end. So I realised last night, sort of about 3 a.m, that the way the submissions were drafted, it suggests that I'm saying apply the structured analysis, but we don't have two clashing policies here in the same way and that would be misapplying it a little bit. So I just needed to clarify that that's really what I'm talking about, is that discipline, which I think is something over the years that that most people have done anyway, but it takes a Supreme Court doing it for, sort of the great, they enlighten everyone, but notwithstanding it's been happening.
It was almost telling us to suck eggs.
Well, that's right.
We've been
That's
doing
right.
that for years.
Yeah, well, that's right. It allows lawyers to cite decisions and so on, but given I'm on the record, I shouldn't say much more. I mean, that's the point of that analysis, and going through the objective 1 and 2 sort of fundamental objectives, and again, cutting to the chase, the council says that it is providing for the health of the water. It's not saying it's not having effects, but it is saying it can provide for the health of the water in this proposal, particularly in light of the modified proposal and the fact that there will be significant monitoring that is proposed now too, which is going to aid greatly the knowledge base in and around this proposal. It's often not a good idea to make submissions on things you haven't heard yet, but I'm going to do it anyway. There will no doubt be criticisms. Well, why wasn't that done before? And you might be thinking the same thing. There's not much more I can say to that other than it wasn't. It could have been yes. There is now a proposal in front of you which is designed to address those oversights in a way, as I said, that there will be accountability. And one way to deal with all that may or may not be through consent too. So we've got what we're asking for, and we say that's appropriate because of the investment that would need to go into undertaking these works. But that's another option. Would it assist you for me to go through this next section and the various objectives and policies that I've highlighted, or?
I think briefly it would. I was just going to ask you a question on the Port Otago, what we've just been talking about, structured analysis and resolving conflicting policies. And there is some evidence in front of me from some of the planners, and Mr. Pemberton may address it as well, that there is some conflict, I think. Some policies focusing on avoid, and there's some policies recognising, I'm not sure if they go completely the enabling way in terms of infrastructure. So there is, they may be in the higher order documents. What I take you to say that sort of issue is being resolved in the land and water plan. Is that?
Well, I think, and the coastal plan, I think.
Coastal.
Yeah, because coastal plan postdates the NZCPS as well. So it's a 2013 document, I think. There may have been changes since that time. I'm not sure. I suspect the Director General will have more knowledge of those details than I do. Well, yeah, I think it has been resolved, and certainly we don't have the old-fashioned enabling. Just go for it, guys. That's not what I'm saying, and it's not what the council is saying. It thinks, again, it's that east-west link idea of there being a pathway through. Now, unfortunately, well, I'm busy complementing this plan, and I'm not actually sure it's a bad thing. In East-West Link, there was a really clear pathway that was provided through the policy framework. That meant that ultimately the Supreme Court said to Judge Tapania's panel, although she might not have been the chair, said, "Oh, you got it wrong with your decision," and that's because there was a clear pathway in the AUP which they didn't follow. We don't quite have as clear a pathway here, and I think it's more about resolution of competing values is the way through on this one. And the reason, though, coming back to Port Otago, Port Otago was about a really enabling ports policy and an avoid policy. And I don't think that's why I'm a bit cautious of sort of over-egging the batter. I think that would probably be going a little bit too far. So I just want to be cautious with that. I talk about then objectives 1 and 2 as their korowai that sits over top of the whole plan. They guide the whole plan and set the groundwork for the details that follows. It's Judge Borthwick's architecture that she's so keen on. There's a clear reference to Māori in that section. It's defined in this plan, but not in a helpful way, in my view. I thought that your understanding from the Porps decision, and why I'm so familiar with that, mind you, is I've been mediating that in the High Court for the last week or so. So that's perhaps why it's so front of mind. But I think the way that that was summarised in that decision was, I thought it was quite helpful, acknowledging the combination of physical and ecological elements and amenity, and then physical and metaphysical concepts from Te Ao Māori, which I think I've failed to capitalise correctly in my 71.
Yeah, I think just looking at objective 2 at your 69, what happened in that decision is because of that metaphysical element of Māori, it's very hard for anyone else to define when they can't. It's easy to define. Because the focus originally in that piece was on protecting Māori first.
Yeah.
That was, and I don't know what the appeals are, but that was changed to health and well-being of the water body, because if you do that, it will protect the Māori.
Yes.
Because, well, you would hope.
Yes.
That here it kind of seems to be slightly different.
Yes, it is. It's a slightly different. It is a different approach. It's more the definition of the term.
Okay.
And I can signal to you that part of your decision hasn't been appealed by Ngāi Tahu. And yes, it has been appealed, but yeah, that's right. As to how that's expressed, and it was about you guys. Your panel. You flipped.
Yeah,
that
purely on the
objective
basis
around.
that, well, not everyone understands or can or determine the effect on Māori. Has to have this wider thing, and if you do that, it's going to protect that anyway.
Yeah, that's right. That's right.
This seems to be the other way around, but you'd hope probably the same should work anyway.
Well, I think the protection of the health and well-being of the water providing for Māori, that it accords with my understanding, and I don't think that's inconsistent with what the Runanga have put in their evidence and their explanations of those various values. Moving on then, the objective 3, which I've already highlighted, enabling economic, social and cultural well-being. And I say that includes management for the purpose of pastoral agriculture. Again, Judge Borthwick addressed that in the Aotearoa decision. She said we don't want to put too much emphasis on pastoral agriculture, but she didn't say it was irrelevant. And then I make a point in terms of the evidence for Awarua Runanga that comments on, perhaps disapprovingly, of the manipulation of water to sustain land uses, leading to the conclusion that the awa is not being managed in a healthy and resilient state, and that we must allow the water body to do what it needs to do. So again, I say that when you look at the land and water plan, whichever way it is, that doesn't necessarily follow. It's not to say that the idea is wrong. I've got no problem with the sentiment being expressed. I'm not criticising it. My client is certainly not criticising it. But it just requires reading the plan a bit wider to figure out how you can find your way through that. At my 76, I'm talking about objective 17, seeking the preservation of rivers and their margin, which includes channel 4. Now, there's an alteration to the channel here and a diversion. That's caused a lot of intellectual horsepower or intellectual spinning of the wheels to try and figure out how to resolve that. And in the nature, given the nature of this proposal, it sort of presents itself as something of an irreconcilable issue. There's no simple answer. So looking at objective 17, I highlight the word preserve from that objective, and that there is a reference from protection from inappropriate development. And about halfway down that paragraph, I say preserve means maintain or keep something in its existing state. So the values are to be preserved, and it's value-based objective, to be protected from inappropriate development. And what the applicant has endeavoured to demonstrate is that the values of the Titiroa stream can coexist with the gates in place. In other words, the tide gates are not inappropriate development if done in the right place with the right mitigations. And I think the infrastructure policies and the in this plan provide some help with that as to when it might be appropriate. And that's objective 9, capital B, is the infrastructure objective. And I didn't around instead it is submitted the restoration of riparian habitat as contemplated by policy 34, including the creation of spawning habitat downstreams of the gates, aligns with the policy direction of the plan. And the fact that restoration of wetland habitat enabled through lease income, which in turn is enabled by the gates, is also relevant. And on the matter of inanga spawning habitat, one of the difficulties we've faced is property rights to undertake habitat restoration. We've mentioned that, and that has limited the extent by which we can do that. I touched then on the East-West Link decision and what I've already said about avoiding, isolating and decontextualising individual provisions. Could you please, sorry. And then I say at my 85, the proposed Southland Water and Land Plan policies demonstrate a planning framework giving effect to mana o te wai that seeks to balance competing interests within the context of the objectives of the plan. It is submitted that infrastructure of the sort proposed by the application is precisely the type of activity that a close read of the plan allows, if appropriate mitigation or compensation can be provided. My client accepts that there are effects on the stream and its values, but says it is still putting the health of the water first. These two concepts are not mutually exclusive, and the applicant therefore seeks a consent that provides for the responsible operation of vital infrastructure that enhances the knowledge of the waterway and ensures values are provided for. A couple of brief comments on Te Tangi, which I accept as relevant. I note that there's an avoid policy regarding fish passage. I say that I can't see how that can be consistently read with the Southland Water and Land Plan. If it was a avoid policy in the way that it could be interpreted, that leaves no room for weirs, dams and culverts in the entire region, best I can tell. So I don't think that can be correct. In my 88, I just make a comment about the extent to which I think there are avoided directives in the Southland Water and Land Plan. Then there is a list of my witnesses, which I've already been through, and takes me to my last matter, and that's the usefulness of expert conferencing between the ecologists. As I've said, I've discussed that with counsel for the Director General. There were attempts, once the evidence was received and we knew what would be conferencing on, to arrange that before the hearing, but understandably with busy professionals, that was unable to be accommodated. I don't think any conferencing would need to be overly complex. I think conferencing could be directed prior to closing the hearing, should you wish to, and it's probably something that can be done on an unfacilitated basis via some sort of AVL facility or similar. It might be most useful to see where we are on that matter at the conclusion of the Director General's case. It may be, and you'll see from Ms. Drummond's evidence, she does responsibly agree with a number of matters raised by the witness for the Director General. So it may or may not be necessary, but if it helps you, certainly something we're prepared to look at. I finished with the table I've already mentioned and then a draft of the conditions. Just if I can take you to page 21, bottom right-hand corner, with the draft conditions of consent, you'll see that we've included within the habitat enhancement, a habitat enhancement plan. Now that's intended to be a management plan in the sense that has been discussed quite a bit by the courts in recent times about how to do those well. We've done our best to achieve that. Just looking though at the objectives, which are absolutely vital for a management plan, can I just ask you under 4A on page 21 to strike through under A the word from the word for. I think that example probably doesn't help much. Look, and it's not the final word, but I just thought it didn't quite fit when I was looking at it again on the aeroplane this morning. So those conditions, happy to discuss, obviously, and to refine and enhance. And I think they're a great improvement on the conditions that were imposed under the previous consent. So look, those are my submissions.
Thank you, Mr. Thompson. Just on that last point, well, not the last one, on the conferencing, I think having worked through all this, that occurred to me that it's a high possibility in this particular, regardless of which way this ends up. I think that needs to occur.
Yeah.
And I don't think it will possibly just be limited to the ecologists. I think the planners need to be involved in how it works. You've asked for 10 years. There's a lot of opposition for that. That would make it 15 if it was granted, because you've already had 5 illegal years almost. So I need to understand how all that works before I ever got to a decision on where it might end up.
Yes, yeah. Well, look, I couldn't agree more. The reason for the focus on the ecologists is there.
Yeah, I think the planners' work will come out of what
Yeah.
the ecologists, if they get to some agreement, and then it's whether they think it works and how it fits in with it.
Well, certainly, yeah, I have no issue with the notion of planning conferencing as well, if that's where you want to head. Yeah.
Well, the options have been put in front of me, as I should be actually just declining for lack of information. I think the conferencing is at least one way of getting a higher caliber, or not a higher caliber. The evidence I've had so far has been very constructive and of good quality, so I just need to get some alignment around these.
No, understood. And look, we don't underestimate, as the applicant, the difficulty in unravelling all this, and we've certainly, and the attempts, I should say quite clearly, the attempts that we've adopted in the briefing of this evidence in the last little while have been very much with that in mind, not only for you, but also for the other parties. We are, we're hearing what everyone's saying and trying to respond.
Yeah. To Tangi, given this is a statutory acknowledgement area, should that plan be elevated in what it's seeking?
Well, well, look, it's very, very important. I don't think there's any question about that. I'd have to give some thought to whether a statutory acknowledgement area elevates a plan, a iwi management plan. I'm not sure I've turn my mind to that.
Well,
I mean, you're required to have regard to it.
yeah,
You're required to, well, I mean, look, Section 8 is probably not quite as helpful and directive treaty recognition and clause as perhaps there should be. And I think by hook or by crook, we've got a much better approach in the various national policy statements, which I think directs a much more appropriate partnership type direction in the context of the Treaty of Waitangi and what it actually says and means. I'm not sure that, though, a statutory acknowledgement in terms of elevates the regard you would have with it. I just need to think about it as a short point.
yeah. Well, and in that context also, in your reply, Section 6E.
Yeah.
A lot of those Section 6 matters are qualified.
Yeah.
As you've mentioned, the protection from inappropriate. Section 6E isn't qualified.
Yeah.
So we need some consideration. I'm sure Mr. Blair or Ms. Ferguson might address me on that. So given you have the statutory acknowledgement area and various other things at play in these, I need to have some understanding of whether I should be elevating that for those policies. I don't want to delay this too long, but the issue you talked about, the 10 years in terms of what you have to do, your client has to do through the Local Government Act. There's also the leasehold issue there, but I might have questions for Mr. Connor on that. I do, but you might have to jump in there.
Well, Mr. Young may be able to help with that as well in terms of the leases, but yeah.
Yeah.
I mean, I've got a reasonable knowledge. You can try.
Well, it's more that if you decline, what's the legal obligation council has under those leases? Because I think I read Mr. West's report that, which I found rather strange, that the leases are running for 3 years.
Yeah.
It's a very short term.
My understanding is they are short term.
So one of the arguments for a longer consent was to provide some certainty for the leaseholders. Well, they don't actually have it now. They only have 3 year. So it's a question of how they operate.
I thought about that and didn't submit it.
Yeah.
There's your answer.
Yeah. Okay.
That would be quite inappropriate. But don't underestimate, though. I mean, you're right. There is not a lot of certainty in the existing leases. That doesn't change the fact, though, that there's been significant investment, time, and effort, and etc. from the local community on these properties. And Mr. Frisbee can tell you all about that because he's been there for a long time and has done a lot of work. So I'd invite you to discuss that with him should you wish to.
And the issue you raised about past behaviour not influencing, I understand all that, but it is quite often a matter taken into account when you're setting term. And as I said before, this has already been unconsented mode for 4 or 5 years. So the 10 years, and I guess that's one of the questions I think I'll probably have for planner conferencing, because what you're promoting, I'm understanding, is as I understand it, is assessing the effects of this on fish passage, iwi values, etc., through what you're promoting with the monitoring in that. So I question the need for 10 years on that. But it's something possibly for planners to be considering how that may all work. Because I can't imagine it would take 10 years to assess all this.
No, I mean, any scientist would tell you the more data, the better, right?
Yeah.
But the other part of it is there are some capital works required as well, and as you have noted, the relationship between certainty and undertaking those capital works. So that's informed the term that's been sought. But yes, I mean, by all means, it could be something for planners to very carefully assess.
This question of the environment on the land beyond the gates that's now modified due to their presence. And it's a kind of a question I had possibly for Mr. Gardner and Young and Co. It's very hard for me to divorce that from the operation of the gates in terms of what the existing environment is. But the complicating factor there is the fact that the tile drains and et cetera in there as well, which aren't related, I think, to this. So how far do I go with that?
Sorry, what do you mean aren't related to this?
Well, the tile drains that actually, there is possibly reading the evidence that sort of indicates to me that they, particularly up catchment, probably have more effect on draining that land than the control gates do. I'm not sure if that's
no, I don't
accurate or not.
No, I don't think that's right. Because the whole system works together,
Yeah.
right? And so the issue is with if you've got the gates, and I know they don't swing like that, but if you've got the gates sitting here and the water pushes up, if those gates are open on a high tide, all the water flows up and it backflows because of the levels of the drains. And we haven't done a comprehensive survey. I mean, that cost 80 grand or something probably. But the level of the drains where they're sitting means that high tide as it goes up is going to push back up the drains.
Yeah.
So
are they a part of the existing legal environment? This is my question.
yes, they are.
They are.
Yes,
So
they are. And
they're already having an impact.
oh, look, yes, they are. They are. And their effectiveness will be significantly compromised if the gates are removed. Now,
I understand all that. I'm
Yeah.
just trying to work out the legal environment.
look, I think they are. And that was the point I made earlier, that I don't think you can, in terms of when you're applying the Hawthorn environment, I don't think you can imagine it as a some undefined swampy wetland habitat. I think that's largely, well, the point to note behind that is the gates up until 2020, when the last consent lapsed, 2020, they were lawful and lawfully established. So their providence is not as an illegal activity, which has led to these changes in the overall environment.
Yeah, it's a complicating factor, that one. Okay, well, thank you, Mr. Thompson. You didn't have any questions or clarification, Mr. West?
No, but it might have been helpful to have had a little bit of information on the time frame behind the 10 years for the financing that works to do that.
I'm thinking that's possibly going to come from engineers and Mr. McSorley, maybe.
Yeah, possibly. I think, though, in terms of timing of the works, as I said, I've characterised it as a term of a consent to reflect the capital cost of doing the works. In terms of the actual timing, in terms of the consent, that's addressed in the proposed conditions, and the management plan as well, which, as I say, has been attempted to reflect a modern management plan approach with clear objectives and certification from the council.
Okay, I think we should probably move on to your witnesses now, because we've taken up a fair bit of time there. So who do we have now, Mr. Connor?
So in terms of reading that out, maybe start.
Yeah.
So these summaries have all been provided to you. I do have a small handful of hard copies.
I do have a hard copy. I haven't had a chance to read it yet.
Yeah, sure. We'll start at 2.
Start at 2?
Yep, start at 2. You just read it, Steve.
My full name is Ian David Connor. I'm a team leader of the Catchment operations at Environment Southland. I'm giving this evidence as project sponsor for this application. Environment Southland's Catchment Management Division has applied for resource consents to authorise the tide gates and a weir on the Titiroa stream. The application had asked for a term of 15 years. As explained by Mr Thompson, the term now sought is 10 years from the date of any application being granted. The tide gates are regionally significant infrastructure that provide significant benefit to the local community and wider region as a whole. The economic value the gates contribute to has been estimated as $1,016,208 per annum. The gates have been in place for a long time and are relied upon directly and indirectly by a lot of people. They assist drainage and provide tide and flood protection along the Titiroa stream. Around 516 hectares of both private and council-owned and leased farmland benefit from the gates. I believe it to be clear the operation of the structures is necessary to continue to provide protection for the land upstream of the gates from a raised water table, which could create greater flood risk and decrease the productivity capability of the land. Regrettably, the previous coastal permit expired without replacement consents being applied for and some conditions being complied with. I've explained this is due to a combination of oversight, staff turnover, a significant flood event, and I think COVID even come into that. Those conditions have now been complied with and the results of the work completed and presented in support of this application. Council recognises and acknowledges the concerns of Awarua Runanga. We have tried to work with Tammy to find ways to address the matters raised in Awarua's submission. I understand from their evidence that they're still asking for the consent to be declined. Council remain open to discussing ways to address their concerns so that the consent can be granted. As explained by Mr Thompson, following receipt of the evidence from Ngāi Tahu and Department of Conservation, Council has reviewed and modified the application in several ways, including proposing the investigation and the installation of a type of fish-friendly gates. Council is asking for some flexibility in the design of the gates so that all options can be considered. We want to ensure there is a balance between achieving the objectives of the gates to control the water table and providing for better fish passage. Council is also now proposing a comprehensive monitoring program to understand how well these steps are working. These amendments sit alongside the mitigation works proposed in the evidence already submitted. To make sure these measures can be actioned in a fiscally responsible way, we are asking for 10 years to 2034. This will also mean Council can carefully investigate all options for the future of the gates. Council staff are keen to continue to engage with iwi and other parties. We remain open to discussions throughout this process. Thank you.
Thank you, Mr Connor. Just on that paragraph 9, probably the matter we were just talking about. So what do you mean fiscally responsible way? Is it so? Can you just explain that to me? Is it a? You know, I asked this question in the context. I had a question down here in your evidence in chief, paragraph 19, about the compromise of council's income. Just the way I read the evidence of how this works suggests that what you get from the leasehold land is spent directly on this system anyway. So how relevant is that?
So what we get from the lease land is spent across the wider Watara catchment for flood protection as well. We have a lot of issues with that.
It's not solely on this area.
Not specifically for this area. So obviously budget comes into that. We just need to make sure that whatever we're doing is responsible, and it's, I guess, there's quite a bit of work in this monitoring program. There's quite a bit of work in this remediation program. There's a lot of cost to it. So we have to factor that in, probably over a period of time. That's why we're asking for that longer period of time.
So is that an annual plan process or something, or a 10-year plan process, or if funds get allocated to do this?
Well, we would certainly be applying to council for funds to undertake this work through the lease land reserve, yes.
I think the lease income goes into a reserve. It doesn't go through the annual plan per se.
That's where I was trying to get to, is the money not there available for this now?
It goes into a reserve off to one side and sits, as I understand it, and sits in that reserve for allocation to the flood protection works. And I won't go, Mr. Connor can answer the rest of the question.
Yeah.
Yeah, no, it's-
Sometimes I don't ask the question straight out because I want you to tell me the answer.
Yeah,
That
no,
is
that's
the
correct.
point of the question, is you're rating this land and money's going, because I've read it goes into reserve. So I'm struggling to understand why you'd need 10 years to be fiscally responsible when the money should be there already to deal with this. Or is that unfair?
Well, there's also the work itself. As I said, the remediation plan, you want an extensive monitoring plan, so you know, there's quite a bit of work involved in this section.
I guess the monitoring and let's propose it's probably one of the questions that the college might have to deal with in terms of what is an appropriate length.
But these works are not funded from rates. So you
No.
made that point a second ago. But so just to clarify my answer, it's a reserve fund. So this is not rated. These works are not paid for through some sort of targeted local
reserve
rate.
fund.
It's a reserve fund. Quite what the internal accounting mechanisms are beyond the natural resources.
And if I may just add, we sometimes have higher priorities for that money. For example, urban flood banks, which we're doing this year, have some of that money, which is a high priority.
Yeah. Well, that leasehold policy, I noted, and I think it has been raised by some of the submitters, I think page 204 of the application documents that I got. The primary use of the leasehold land is for flood management, and all other uses of subservient. That's what it says. And there are policies in a number of the documents, including council's own planning documents, that encourage restoration, etc., of areas, coastal areas and waterways and wetlands. So did your department give consideration to actually, well, okay, we own most of this land, maybe we should actually give effect to what iwi are asking for? Has that been considered?
I think other departments in the council have leading off our land projects, and I think it was raised that we've already, it's been over 440 odd hectares retired from land that was bought under the Public Works Act for flood control purposes in that area alone. So
is that the area below the bridge mainly?
both.
So the areas above the bridge would be the bush
Yeah,
area?
biodiversity and
Yeah.
that kind of thing. Yeah.
I did actually have a legal question around that, Mr. Thompson, which I should have asked before, is because you raised that, and for my purposes, given that's already happened, part of a wider, is it relevant to the positive effects of what I'm considering? Was that done and dusted?
I think it's done and dusted. I mean, the reason for making that point was really to respond to a lot of the evidence, which to my reading anyway, sought to paint the council as taking a really cavalier attitude as an organisation to these sorts of things within this area. Now that may or may not be unfair, but it's the sort of thing that I just didn't want to leave hanging. And look, it's important to these guys. They've made the point to me since I've met, when I say these guys, I mean the Catchment division. When I've met with them and taken instructions, they've made it very clear, look, we're doing some really important ecological enhancement down here. Now, is it enough for certain parties' desires and views? It's not, and that's okay. You know, we can have different views about these things and still be friends. But it was just really important to me that you didn't form the impression that this area of land was being controlled for inundation for pastoral farming purposes, and we're not worried about anything else. It's much more complex than that. And this council is doing an enormous amount of work in that space. And that's why we say, we talk about consultation with the community for the long-term future of these gates. We don't know what's going to happen in the future, but there's a very detailed process to be undertaken with this wider community, and stakeholders have already said to determine what's going to happen in the future.
So how does that occur within the context of this area? Because as we established before, your leases for only 3 years. What sort of conversations do you have with the leaseholders around that? That doesn't give them a hell of a lot of certainty. 3 years.
It's probably a question for the property manager who's not here, but yeah, Liz might be able to answer.
Yeah, well, I wondered if Mr. Frisbee might, because I'm assuming you've been a part of those discussions when your lease comes up for a renewal, because when I look at this plan, the council controls quite a bit of the lower bit down here. There is a private block there which shows none of the drains, so I'm assuming it probably is drained. But at least that bit there, who is that leased to? Is that you, Mr. Frisbee? So you're right in the gun in that area there.
Yeah.
So that's the main effect, I'm assuming. So what sort of surety do you have with your lease that's going to remain like that?
Yeah, well, originally we got 10-year leases for a start, but in latter times they've done them 3 years because we don't need to go through lawyers and things, and it's just done, sign a piece of paper and we carry on. But that's been like that now for well, I've been there 42 years, so we got a right at the start we got 2 1-year leases, and then we got 20 years, and then we've had 3-year leases since then. So
yeah, okay. So that was more of an administration thing rather than a changing of how they might be thinking of what might happen in this area.
that's what I would say.
I know Elise or Mr. Thompson or Mr. McSorley could correct me if I'm wrong, but I think, is it 20 years at least becomes a subdivision, or is it 25?
Wasn't it 30?
So, I think they dropped back.
Did they? Oh, okay.
I'm not sure.
You have to ask my property
Yeah,
partners.
could be 30. Yeah. You don't know offhand, Luke or Ms. Ferguson?
25, 30, I think
Yeah.
it's quite, I thought 30.
30, okay,
Quite
I
a
could be wrong.
long time.
Yeah, it is a long time, and it kicks into a subdivision. So is that your understanding as well, how your
Yeah, to be honest, I don't handle the property side of it. The property manager does. So I don't really not over the lease
I was
arrangement.
thinking more of what council's long-term thoughts might be for an area like this,
Well,
when there's a clear interest to iwi and.
yeah. Well, I think that's the point though, because before any decisions can be made around the leases or indeed the future of the gates after this process, as a matter of law, council needs to take into account the views of those who are affected. Now, those are going to be stakeholders, they're going to be iwi. It's going to be probably fish and game organisations like that in terms of the whitebait fishery, and really crucially the locals. I think one of the and that's a conversation that needs to be had with the community. And so I don't think we can give you an answer, well, we can't give you an answer today as to what the long-term interest holds, because that's a conversation that needs to be had. Now, that might influence you on term. It's a matter for you ultimately, and you've heard me on that already.
Yeah. Okay, thank you. The only other question I had for you, Mr. Connor, you talk about in your paragraph 5 the benefit to the region as a whole of the gates. I guess what I'm hearing, it's not so much just the gates, it's the whole package they sit within. Is that what you're meaning? Because the gates themselves appear to be protecting a small, in the context of the wider catchment, a smallish sort of area, and you do have that diversion channel up the top.
Part of the Greater Ontario Flood Protection Scheme that was set up under that. So, yeah,
So, yeah, because I kind of read your evidence in the context of the wider infrastructure, not just necessarily the gates. So, yeah, what I'm trying to establish is how significant the gates are in that picture. And I think it's probably, I know Mr. Frisby's view because he's directly affected by them. It's what the engineers might tell me that I'm interested in that sense. Yeah, and I guess I for you, I also had the question around the tile drains. What's the most important there, the tile drain or the tide gate? But I guess the answer there is that they work together.
I think
What I heard before.
one clarity there is that 9 hectare, that's the inundation area. But all these tile drains that feed into that, they're not going to work because they're on a gradient downhill. So they're not going to work if 9 hectares inundated from the, you see what I mean? It's going to back up to some extent,
Yeah,
particularly with raised water tables and all that kind of thing. So in actual fact, the spread of that is a lot greater than we may realise.
so the 9 hectare that gets inundated, which is nowhere near as big as that polygon, I'm pretty sure. Can you answer that now, Mr.
That
Kane?
it was a unit error.
Yeah.
It was supposed to be 9 square kilometres.
Yeah, I was thinking this is a lot bigger than 9
Yeah.
hectares.
Apologies for that. It's a typo which has just slipped through without me questioning it.
Yeah. So that inundation area, though, it is 9 hectares that gets actually inundated if the gates went there. Is that correct? Or
That polygon area which I drew was the area, so all the drains which back up into that area have water level increased. So I'm saying the drainage within that polygon
yeah, I understand
is
that.
directly affected.
Yeah. So the area that actually floods, yeah.
So it's-
that was 9 hectares, was it?
No,
No,
I
sorry.
wouldn't, but I haven't put a number on anything which
Okay.
actually floods, because it's more the drain is completely full.
Yeah.
So the ground adjacent will be very boggy, but it's not necessarily surface water inundation.
Interesting enough on my site visit, some of it, have you had quite a bit of rain down here recently? Because there did seem to be a bit of water even further up lying, and there are areas that are also quite reedy. I'm assuming would they be areas that probably don't have tile drains or something in them?
Yeah, likely.
All up by Fleming Road's all drained, all up that end. And even down the bottom end, there's all drained.
This seemed to be more up the middle, actually.
Well, we had 6 mils of rain yesterday morning,
Yeah,
and we had 20 mils of rain on last Monday, I think. Yeah, so that things were quite wet this week. Yeah.
And we don't know how many drains are in private land and how much money's been put into that over time.
I'm guessing, Mr. Frisby, you wouldn't be in favour of a test of leaving those gates open in a high tide to see exactly what did happen.
Oh, well, my first years there, we didn't have gates, so I know exactly what happens there. And we have had the gates removed before for a couple of months or 6 weeks, getting them fixed, so that has happened, but it was done in the summertime, which is not quite so bad.
Yeah. Okay, well, thank you, Mr. Connor. I'll just see if Mr. West had any questions or clarification.
Just a couple. Gotta be careful with this one so I don't go out of bounds. Mr. Connor, is the role of the Catchment Operations Division in terms of the drainage of the area arising from the installation of the gates as part of flood protection rather than drainage protection?
I think they possibly go hand in hand, don't they? Because if the gates are open, that allows the tide in, so that's flooding.
I was just, I might not have expressed that well, but what I'm trying to ask is maintaining drainage of land a normal function of catchment operations. But I was trying to express that in a way where I was bringing you back to the original flood protection scheme as possibly a reason why we're involved in drainage in this instance.
Yes, that would be correct. Part of our function, part of our role is land drainage.
Yeah.
Maintaining land drainage.
The other one is in your main evidence, you've talked about how the gates require little in the way of maintenance. Is there any information on the design life, given that they're already 38 years old?
So I can only go on the information I have, and Mr. Young may be able to provide more. We had to replace some bolts that I'm aware of in the last 5 years, I think. I've only been in the division 5 years, so I'm not aware of any other maintenance on this particular structure, but I could be wrong. Yeah, you're referring to the life of the gates as well? Well, yeah. Can only go, but the gates were put in 1986, so we've had one lot of maintenance that I understand. At least Collins can shed some more light on it. So I guess that's why I thought, they seem to be still in reasonable order, so they could go for another. That's how long, really.
Thanks, that's all I've done.
Okay. Thank you. Thanks, Mr. Connor. I think that brings us to Mr. Young now.
Just hope it's breaking up.
Yeah, that's all I'm.
Twice it's happened.
Yeah.
But I'm better.
Welcome, Mr. Young. Okay, now you have a short summary.
Yes, I have a short summary that's there.
Thank you.
You're happy with me reading?
Yes, thank you.
My full name is Colin Shed Young. I'm employed by Southland, Environment Southland, and have assisted in this application. My evidence is to explain some of the history of the tide gates and where and parts of the Lower Mataura Catchment flood scheme. Current tide gates were installed in 1986 to replace a set of wooden gates built after World War I. The weir was constructed to reshape and control the flood spillway as a flood spillway. In 1970, as part of the multi-project in the wider Mataura catchment, purchased land in the Lower Titarawa catchment for flood protection and leased it back to the farmers. The lease allows for continued farming in the area of the bush and wetlands and to be maintained by the council for conservation. Council required lessees to improve the land and also undertook works itself, including installation of tiles, mold drains, and installation of flat gates for drainage. Leases provide income for flood protection works and maintenance in the catchment, including for conservation. There are now 7 lessees and 2 blocks in private ownership. The gates and weir contribute to the lowering of the water level in upstream, providing drainage and tidal flood protection to farmland. The gates control the water table up to the railway embankment, up about 7 kilometres upstream, and it's shown on Mr. Collins' appendices. Gates also help to keep water table high downstream, where there's an area of wetland. The structure is regarded as a strategic part of the infrastructure by the council. I've also described the cut-off between the Titarawa cut-off and the Mataura River. The purpose of the cut-off is to reduce the water flowing down the Titarawa stream floodway, to reduce the water table in the Titarawa stream side. And that's my brief summary.
Yeah, thank you, Mr. Young. I guess you probably heard the questions in the dialogue. Until you gave that summary, I had a question in paragraph 7 around the evidence in chief. You talk about the gates there perform functions associated with the wider Mataura River catchment. How wide? I guess because the way I read your evidence, it tends to suggest that the cut-off up the top is more significant in terms of flood management in this particular area.
There's two components to mainly for the cut-off there. One is for drainage. In other words, we reduce the water levels down the whole Titiroa side, because we run the water from the Titiroa directly into the Mataura River. There's also a set of gates at the top there, which we can actually redivert water back down the Titiroa side itself. But by reducing the amount of water coming down the Titiroa side, we can actually lower the water table, especially on the up from there down to the Roa embankment. And that helps the management of the pastures all the way down
So
through.
that's in flood conditions you do.
Just in ordinary conditions.
Oh, okay. So that diversion's always weak.
Well, it's operation then, and you can actually operate it in flood conditions and also in dry conditions or normal conditions. But the idea is to reduce the amount of water coming down the floodway in its entirety.
Yeah.
When I say that, there is during a flood event in the Mataura River, when we have water coming down, water backs back up to the cut-off and then goes down the floodway itself as well. So the idea is to reduce the amount of the smaller floods and that would break out down through there to control that, to assist that.
Yeah.
But in doing that, it also assists in the size of the structure that we need to build down the bottom. Otherwise, we've got to build a larger structure to deal with bigger flood flows again, normal flood flows.
Now, that's helpful because you did say that it's those gates. It's not their primary purpose, the flooding, but it seems to all work together. These things.
I think when you say flooding, it's actually tidal flooding we're sort of dealing with, not riverine flooding coming from the river coming back down into that.
Yeah, okay.
There's a sort of dual function, tidal function,
Kind of where
as well as drainage.
Yeah, kind of where I have a slight issue whether that's actually flooding or just a natural process. That's for someone else to answer. You also talk about, and it's a point that Council raised as well, the role that the gates play in downstream. It's actually probably more of a question for Ms. Drummond, actually, but she can hear it and answer it later. But the beneficial effect of that, isn't that sort of artificially creating a different environment as well? It is actually more for Ms. Drummond, I think, but you've raised it in your evidence. And I know areas there have been retired, but it's going to keep that area probably wetter for longer. And what I need to understand the significance of that, I guess. But it was raised in your evidence, but you probably don't need to answer that question. You said at your paragraph 16, I think you indicated that there's about 14 years without the gates. There was a significant flood in 72. Do you have any, and Mr. Frisbee might probably answer this in his evidence, but what was the impact there when the gates weren't there for that period?
That's the period where we had to remove the gates to repair the hinging. That was just due to vibration. When it shuts fairly fast. It's actually damaged some of the hinging, so we had to repair that. We also had to reface the gates because it started with corrosion. So in doing that, we physically removed the gates, brought it back into town, refurbished them, replaced them.
Okay,
So
so,
in that-
yeah,
in that time, Mr. Frisbee can also probably confirm that the tide in that period of time was only, I think, 4 months, 4 months.
yeah,
We
I
tried to
probably,
minimise it, but what happened was that we noticed that we started getting people, or like some of our lessees further up, saying the water table's starting to rise considerably and things are getting wetter and wetter. And our policy at that time was to try to minimise the amount of disruption we had onto the farming practice. So we tried to do it in summer, knowing the water table would probably be lower. But even then, they noticed considerable raising of the water table during that period. I remember having to some phone calls requesting us to hurry up and put the gates back on.
Yeah.
On that basis.
so I may have read your paragraph 16 wrong, because I took it from reading it when they were demolished in 72 in the flood, that they weren't replaced until 1986, but you're not telling me.
Okay. Yeah, that was the old gates.
Yeah.
The old wooden.
So the old gates were done up, put back in, but then they were replaced in 86.
No, unfortunately, no, I misunderstood.
Washed away.
Yeah.
What happened was, when I started in 79, those gates were also in a condition which weren't fulfilling its purpose. They were horizontally swung gates. In other words, they were pinned at the top, and they were flat gates, and they were solid timber ones. And due to the floods in 72, they were damaged and they were not repaired from that period of time. And from then, what I understand is that the water table in that area was slowly rising. But as part of the scheme of the flood protection for Matara, we could put the gates in as part of that as well, to enhance the area for wildlife conservation, as well as all these, as well as part of the farming practice, also could be actually enhanced as well at the same time. That all come out in the economics of this lower end scheme there. So that's the integration you're asking about before, is why is it integrated with part of the Matara scheme? Because part of the economics of that there, you had to have the value of bringing some of that land back into production to assist in the internal rate of return for that whole scheme.
Okay, well, it's quite interesting that, because your paragraph 20, your footnote, talks about the government's policy that catchment boards then were required to purchase, protect or purchase. So you guys actually purchased most of it, but then allowed it to continue to be farmed.
The policy at that time was purchase or protect, and that was the government policy. Our council at that time said that they were quite happy to purchase land on a buyer-seller negotiation under compulsory acquisition. So therefore, what it did allow us to do is put the flood banks on the true right bank of the Matara River. If we offered to purchase on the true left bank, which is the floodway, which included the Titara side there, as part of the scheme. So therefore, if we put banks on the true right bank of Matara, we wouldn't be in a situation where we'd be challenged that we're increasing the flooding down on the true left bank side. That was the policy that the council adopted then. And then, once again, is this possibly why we've still got a couple areas which the landowners didn't wish to sell to the council.
Okay, well, thank you very much, Mr. Young. I don't have any more questions for you. Any questions or clarification, Mr. West?
Well, possibly it's actually a combination of Dave and Colin. In the draft conditions I put attached to my report, I'd suggested maybe some sort of signage or warning thing be placed on the weir for regard, in case people were moving around on the river. That the weir, so they'd be aware of the weir when they got close enough. However, thinking back on that now, would that be appropriate on something that's effectively a spillway? Or would it be an obstruction as well?
Well, for where the weir is to come into operation, normally we would have a fairly reasonable sized flood event. And it would come in from the top, and most people would barely have access to that area. So you could put signage in there, but you still got to, most people shouldn't be in that situation where they'd be in the middle of a floodway knowing that you'd be in that situation. I don't know what the advantage would be.
I'm trying to get, or I think I might have made a mistake. What I'm trying to get at is you don't want an obstruction on top of the weir.
Obstructions on top of weirs are not good policy.
Paragraph 21 of your evidence, you said that there was an agreement that the land acquired would be leased back to the farmer. Is there any sort of further onus on the council to look after it beyond the lease arrangements and the lease policy? Is there ongoing requirements on us to provide for that leasing? I haven't expressed that well either. No, please, I'll withdraw that.
I think that's kind of the question I had for around the legality of the leases, the obligations there for Mr. Thompson and Mr. Connor earlier, is really you try to get to how that complicates things, I guess.
Well, Mr. Frisbee's up next, if you're ready, sir.
I think Mr. Frisbee's been chomping at the bit to answer quite a few questions. And he's probably the man with the knowledge of this area.
Yeah, my name is Leslie Clifford Frisbee. I'm a farmer and agricultural contractor from Southland, and I live and farm at Titiroa Stream area. I made a submission in support of this application and have been asked by council to help you understand what it is like to be a farmer who relies on the locks. I've been farming in the area since 1982 and was in the Titiroa catchment before the current gates were there. Pre-gates, the land was very wet and full of gorse and rushes. Because it is so wet, it was uneconomical to farm. I now lease 4 blocks from the council and run 2,500 ewes, 600 hoggets, 40 rams, fatten 300 cattle, have 250 calves and also a few deer and a few cows. Back then I came to the area, if a big flood came through or there was a big tide, portions of the farm would go underwater and impact on the farm was significant. Once the gates were installed, I did a lot of work on land, including fencing, installing tiles and mould drains, and that has meant the land can now handle a flood as the water table is much lower. I agree with Mr. Young that the gates control the water table up to the railway embankment. I'm very worried that if the locks are removed, the land would no longer be farmable. The drains on their own are not enough, and I understand water will push back up them if the gates are removed. The community relies on the gates, and I employ 5 full-time staff all year round. Most of our work is local. Without the locks, I'm sure my agriculture contracting business would also be in trouble. In my 40 years in the area, regularly been good runs of whitebait along the Titara stream and plenty of eels and trout and other fish.
Thanks, Mr. Frisbee. Just that last comment there, those runs of whitebait, et cetera, are they upstream or downstream?
Upstream of the locks,
So there are quite good runs
all
upstream.
year round, yeah, all year round. And there's probably significant amount of adult whitebait that are quite big, you know, they're right at the moment, the Titara is full of whitebait, so upstream.
I understand the adult fish live in the fresh water, don't they?
Yeah.
Just in terms of your experience with the big tides, when the gates weren't there, so how often did that happen and how long was the effect?
Well, it's on the moon on the moons, full moon and new moon.
So once a month you'd get a big tide that was
Yeah, probably
around that lower.
could be twice. Yeah, but we'd normally get one good one a month. Yeah.
Yeah. And how long is your drainage affected for after that?
Yeah, well, it just means that the drains aren't. It fills up in there by a good metre away up at Fleming Road. It lifts a metre there, and there's areas of ground where your ditches all come out of things which actually gets inundated with water as well. So you can be a 2 acres of inundation of water right away up at Fleming Road.
Okay, well, just on my site visit, it appeared to be a lot sort of drier up the top.
Yeah.
And drier at the bottom, but the middle bit, as we said before, the middle bit seemed to be a bit damper.
Yeah.
So that's probably more to do with on-farm improvements, would you say?
Yeah. Yes.
So what is the difference in effect, say, down in your bottom block, just above the gates, compared to what happens up Fleming Road? Because to the untrained eye, the Fleming Road area looks pretty dry to me.
Yeah. Yeah. Yes, that's right. It's the bottom piece is that I've put a lot of drains in down there, so it's just and the whole farm is actually drained now. We're not allowed to put any more drains in.
Do you farm up top the Fleming Road area as well?
Yeah.
Can you maybe show us on the map where you're?
Yeah.
I know where your lower bit is, but I'm not sure about where the top bit is.
Fleming Road runs round there, just like that. Oh, I'm above Fleming Road, right up to the railway bridge. Oh, no, not quite. All that piece there is my top block.
Yeah.
And I'm also down this one here.
Okay. Yeah. That's just
And in there, all in there.
so that block just above that patch of bush is your.
Yeah, all right out to the main road there.
Yeah.
Yeah. All that there. That block there is privately owned. That's Mr. Morton, who's down there, that block there. It says Mr. Holmes's block is over here on the side of there.
And that goes up the hill.
Yeah, up onto the hill, yeah.
Okay, thank you. So what's the impact up at the railway embankment? Because that's a fair way further up as well.
Yeah, not so much up there because it's, but that's where the tide's affected, right up to there.
Yeah.
At Fleming Road, it'll lift a metre. So when you go over that bridge on low tide and then you go back over on high tide, it lifts a metre. So
Yeah.
on those, especially those moon tides.
Okay. Yeah, well, thank you very much for that. It's always good to have local input on these things. Any questions or clarifications? Steve?
Oh, very brief. The lower block, is that entirely within the red area marked by Mr. Gardner's evidence?
Yeah, I have, yeah, it is.
So that's 147 hectares
Yeah.
in that area.
Yeah, that's right.
Thank you.
Thank you.
Well, that takes me to the expert team. Block 11:15. I'm not sure what's that make it 2.25 hours. Are you intending on breaking or pushing through?
I think given the time constraints, we might push through. Yeah, everyone's happy with that.
Yep. Well, that takes me to Mr. Gardner. Thank you. Now, do you wish him to read the summary he's prepared and put in front of you, or would you like to take questions?
Is there anything new in your summary, Mr. Gardner? Maybe just give us a quick brief overview, because I always find it helps me zero in on the issues again.
Sure, okay. Thank you, Commissioner. So in essence, I've built a 2D hydrodynamic model of the area using industry standard techniques and software. The tide gate is in that model, so it operates dynamically. By that I mean it opens and closes with the tide. So the base model has it opening and closing on a 6-hour cycle. So the tide levels which we've used in the model are based around Land Information New Zealand supplied LINZ, like the LINZ tidal nautical almanac. So that's what the high and the low tide and the mean high water spring and all the different range of tides are provided by Land Information New Zealand. So if you see standard data and metrics in the same datum, essentially we've run 4 main simulations. We've run a simulation without the tide gate. We've run a simulation with it as it is running currently, where it's opening and closing approximately every 6 hours. And then we've also run 2 further simulations with the tide gate staying open for slightly longer either side of the high tide. So opens for an extra half an hour either side, so an extra 1 hour in total, as well as 2 hours. And so the model results show that by completely removing the tide gate, it has a significant impact on the water levels right the way up the Tiriroa stream and the subsequent drainage network. I was getting increases of in the order of about 0.8 of a metre up quite a long way up to very close to Fleming Road. And I'd just like to point out that we haven't conducted survey of the drain, and so there's a lot of assumptions which go into building a model, especially when you haven't surveyed the drains. And so we've deepened the LiDAR survey by about 2 metres below the land level, or what it's estimating the water level is. However, if those drains were dug, if there's a bit of a hump in the land, and that drain had been dug a little bit deeper to maintain a constant grade, then it's not unforeseeable that the extent would easily go all the way up to that railway embankment as Mr. Frisbee. So I don't think my model should in any way discount the extent of inundation put forward by Mr. Frisbee. And so essentially, with the standard tide conditions which we've modelled, if we open the gates by an extra hour, the water levels in the drainage canals go up in the order of 10 centimetres. And if it was 2 hours in total, 1 hour either side, then we're looking in the order of 21 centimetres. Tides, as Mr. Frisbee will know, are quite complex. They operate around the moon, but they also operate in regards to the weather conditions at the time. So in terms of storm surges, low pressure systems, etc. And so you get a different tide every day. What I would like to highlight more importantly, rather than whether or not the exact tide scenario which I've selected in terms of is it mean high water spring, is it mean sea level, that this model should be taken as a relative difference. And so what it's showing is that wherever the water level is at the time, it's going to be a relative increase in water level if they're removed. And from conversations with Mr. Frisbee on site, he's indicated that he's manually dug in a lot of the tile drains himself, and he's placed them at that water level, at the existing water level. So if that current water level, no matter where it is, increases, this tile drainage system will be impacted.
Yeah.
Okay. Thank you.
Well, thank you. I think our discussions today largely sort of answered a lot of my questions that I had for you. Had you confirmed that 9 hectares, so that you're not entirely sure where that is?
Oh, so that was the,
Oh, that's right. Yeah,
there was a square kilometre.
yeah, square kilometres.
So that was
yeah.
a big oversight on my behalf. I apologise for that.
Yeah, I was thinking, sure that's greater than 9 hectares. So, so it's 9 square kilometres that you're saying is the most impacted, but
Yes.
the constraints your model is such that the delay observations, if you like, the impact can and possibly does stem.
Correct. And a very quick calculation, just by drawing a quick circle, it comes down in the order of 12 square kilometres if you went all the way up to the railway embankment.
One of the issues that have been raised is the impact of sea level rise. And I know you haven't really modelled that. You've used, you talk about in your 42 to 44, but I don't think that relates to sea level rise. It's storm surge, I think, the 0.3 or something.
Yeah.
I guess the question that's been raised in that is will this thing work when we're faced with higher tides? Bringing in questions around, well, it's not going to work in 20 years' time because the thing's going to flood anyway. I guess is what the question that's been asked there.
Yeah.
Do you have a view on that, or is that something that can be modelled?
Yes, that is something which can be modelled, and in earlier versions of the model, one of the reasons why I didn't include it is the final version of the model we didn't do that. A sea level rise run could have done it, but I didn't see it as relevant to this particular evidence, so I tried to just keep it nice and clear and simple with 4 scenarios. But the gates would likely, like in a spring tide, for example, we can see inside that the water level gets right to the top of that gate as it is. Is that fair, Mr.
Does go over it.
So it's just here. In fact, I thought it would probably just be lapping over the top. So on those specific spring tides, with 0.3 metres of future sea level rise, say in 40 to 50 years' time, we would expect they would be overtopping on a spring tide, but it would still be providing benefit for your standard tides. And if it is overtopping, the entire water won't be going up that gate, will still be blocking some of that flow from going up.
Yeah.
But they will become less effective with sea level rise, it is fair to say, but still be providing benefit.
So that freeboard will act, will have a benefit until those large spring tides you talk about.
Correct.
Yeah. Do you have any sort of sense of how much would be affected in those?
Well, I did run a scenario in an earlier version of the model with and without the gates, with sea level rise. So even with the gates, some of the very low land is actually likely to start being more actually physical inundation spreading out from those drains as sort of portions of land which do get flooded. If you didn't have the gates there at all, then I would expect that it would start, there would be ponding out some of the drains in quite a significant area, but I haven't done that. At this stage, I don't have the maps or model results showing that to speak factually to.
Okay. More excited in the resurgence. Any questions or clarification, Mr. West?
I think you've covered a lot of things off for me, but just about the saltwater intrusion mentioned in your evidence. Do you know how far up that might go if the gates weren't actually there? Or is that something you can't predict at this time?
That's something which goes beyond my area of expertise. And so I can predict that saltwater will travel up the drainage network, it will be held up high for a sustained period of time, and from my general experience being in catchments such that these saltwater will protrude into the surrounding land. The nature of the existing groundwater aquifers and how the groundwater behaves is quite complex, and it's beyond my expertise to comment on the specific extent of saltwater intrusion.
That'll do for me.
Okay, thank you very much, Mr. Gardner. Ms. Drummond now.
So my summary, evidence and rebuttals a bit longer. Do you want me to read out the whole thing? There's quite a bit of additional information in the summary.
Let's focus on the additional information, because I think that's reasonably important.
Sure. So the Tiraroa tide gates restrict the free passage of fish upstream and downstream of the structure when closed, which can affect the migration of native fish within the catchment. Passage is available when the gates are open, which is half of the towing cycle, although in-stream velocities may limit upstream passage at times for early life stages of fish, as well as weaker swimming species such as enough. From an ecological perspective, the best outcome is to remove the gates to provide unobstructed passage. However, if this is not functionally possible, modifications or replacement with automated or fish-friendly tide gates is the preferred option for newer replacement gates, as per the fish passage guidelines. It is now proposed by the applicant that modifications to the existing gate structure are undertaken to provide an improvement to fish passage. This is condition 9. With associated monitoring to confirm success. That's condition 10. To mitigate the potential impacts of fish passage caused by increased velocities in the diversion channel compared to the main stem of the channel, upstream and downstream of that diversion channel, when the gates are open, baffles were originally proposed. Upon further consideration of the water level, the depth restrictions at high tide in that diversion channel, I now suggest boulder clusters are used in the diversion channel to provide resting zones for smaller fish when those velocities are higher. It will also provide predator refugia for the smaller fish when the gates are closed. A range of potential enhancement options were originally provided for further consideration and consultation, which did not occur. These options have been updated in response to landowner restrictions and include improved inunga spawning habitat in the Tiraroa main stem and tributary enhancement for a total area of approximately 1.1 hectares. The ring drain enhancement downstream of the gates has been removed from the aquatic compensation package. A summary of the proposed mitigation and aquatic compensation is provided in table 1 of my summary evidence, with indicative areas shown as figure 1, which is also provided. A habitat enhancement management plan is proposed as a condition of consent. It's conditions 4 and 5 to provide confirmation of the areas and methodology of habitat enhancement and associated monitoring to confirm success. In my opinion, if the gates cannot be removed, the proposed mitigation in table 1 will reduce the level of effective fish passage. Aquatic compensation measures can improve the natural values in the Tiraroa stream near the tide gates and go some way to reducing the level of adverse effect from the tide gates. Conditions are required to ensure that the proposed gate mitigation and habitat enhancement works are undertaken with an appropriate level of investigation, transparent methodology, and monitoring to compare effectiveness. Collaboration with the Environment Southland Science Group and stakeholders, including input and approval of proposed works and associated monitoring plans, is highly recommended. And then I have a rebuttal to submitted evidence by Ms. Jane Bowen of Department of Conservation. So I just provide the following rebuttal of her application. I agree with Ms. Bowen that the gates, when closed, impact the migration patterns of native fish within the catchment, and that there are design features available to lower that potential impact if the gates remain. So this could be an appropriate solution. I also agree with Ms. Bowen that insufficient information, consideration or feasibility is being given to the use of these solutions to improve fish passage in the Tiraroa stream. Increased migration ability is now provided for with the condition to provide fish passage when the gates are closed. I agree with Ms. Bowen that the side hung nature of the current gate should remain if fish-friendly modifications are made to the existing structure. These are preferred to the top hung hinge gates, which do not stay open for as long in passive designs. It is recognised that further investigation is needed to ensure the proposed approach is effective. Therefore, conceptual design should be discussed with fish passage experts prior to being installed, and monitoring to provide effectiveness will be required. In paragraph 15, Ms. Bowen mentioned self-regulating tide gates are considered minimum standards for existing gates. These rely on a stiffer or counterweight to increase the amount of time passage can occur. But this design on a side hung gate will likely increase the water velocities when the gate is closing, because it will restrict the level of passage. So I don't believe that will provide effective passage. It won't improve the situation to a level that will be helpful, in my opinion. A bespoke letterbox opening design on one of the gates could be the best outcome to mitigate effects on migrating fish, both upstream and downstream, as it will enable, if designed correctly, passage through the gates when they're closed with minimal tidal inundation. When considering the effects of the management hierarchy, this option falls after avoidance within minimise. This is because while the impacts to fish passage cannot be reduced through providing passage when the gates are closed, it will be at a lesser degree than if the gates were not present. So it will provide increased passage, but not to the same level as if the gates were not present, clearly. In regard to water velocities in the diversion channel, I agree that at times upstream passage could be restricted for some life stages of fish. Mitigation for this is provided for in the form of boulder refugia habitat within the diversion channel to provide fish resting areas. Upon reflection, I agree with Ms. Bowen that the depth of channel will make baffle installation difficult. Therefore, I propose the boulder clusters, which as said before, will provide predator refugia as well. In paragraphs 36 and 30 to 38 of Ms. Bowen's evidence, she discusses the velocity survey. I'd like to make the following clarifications. The velocity survey was undertaken downstream of the gates and representative diversion channel habitat. Surveys couldn't be undertaken within the gate structure itself due to depth of the channel, requiring the use of a river surveyor. There's a boat type profiler that moves along the top of the channel, and the gate structures wouldn't have enabled that. 40 minutes of constant profiles, so back to back, bank to bank, were taken immediately after the gates opened. This was approximately 8 transects. And the maximum velocity recorded in one of the profiles was recorded 38 minutes after the gates opened, not 140 minutes after opening. This was a type of typographical error. It is recognised that while the velocities measured across the width of the channel would not impede most species upstream passage, some life stages, so the very early fish life stages, and some weaker swimming species could be impacted. A condition that requires the installation of boulder clusters is now proposed with additional velocity surveys at different locations within the channel to identify the best locations for installation. Ms. Bowen also comments in paragraph 38 that no comparison to fish swimming speeds was provided in the PFE reports. I note that this was provided in paragraphs 37 to 38 of my evidence in chief. In paragraph 34, Ms. Bowen disagrees with the minor level of effect on fish passage as discussed in the fish survey results. I would like to clarify that this was related to open passage being provided for in the diversion channel when the gates are open. Therefore, in comparison to other tide gate or flood control structures that form a full-time area, passage can occur when they are open. This is confirmed by the presence of migratory species upstream of the gates. I agree the gates could impact the level of and success of migration and spawning success through temporarily limiting passage at a level that is more than minor. In paragraph 48, a fish bypass option is discussed. I agree with Ms. Bowen that this could be, that it would be more effective to modify the gates that are present. However, if an option to install an effective bypass is available, this could be investigated as part of condition 9. In paragraph 16, I agree with Ms. Bowen that limited information is being provided on the proposed inanga spawning offsetting. It was the intention of the mitigation options report that further detail would be provided after consultation occurred, or as part of consultation. As per proposed conditions 4 and 5, a habitat enhancement management plan is proposed to ensure that these locations, methodology and monitoring is undertaken to address these concerns. In paragraph 40, Ms. Bowen comments on the number of surveys undertaken for the salt wedge and spawning surveys. I agree that repeated surveys would provide more clarity on the current spawning conditions and success. One salt wedge survey was considered appropriate to identify if the salt wedge extended upstream of the gates, which was previously not confirmed. It was considered to be downstream of the gates, and therefore if spawning could occur upstream of the gates when they were closed. The survey is considered accurate as it was done during conditions when spawning would occur, during a spring high tide, during base flow conditions in the stream. However, I agree that further surveys can be done to refine and confirm the salt wedge extent as part of future conditions to confirm those proposed enhancement areas. This is now proposed as condition 11. In response to paragraphs 56 to 57 of Ms. Bowen's evidence, further detail on the Inanga spawning survey results can be provided as locations were spawning locations and habitat mapping areas were GPS mapped and photographed. Waypoints of all high, moderate, low and unsuitable bank habitat upstream and below the gates was mapped by boat by Aquatic Ecology Limited, who are experienced in Inanga spawning and habitat surveys. Low and unsuitable habitat was considered for enhancement. Repeated surveys are proposed in updated consent conditions to assist with understanding the current conditions, as surveys were completed in 2022 and conditions may have changed. This will provide more detail and certainty on the enhancement options available. I agree with Ms. Bowen that the outcome of Inanga spawning is uncertain. However, note that it would be an improvement to current conditions. Further clarity on the proposed approach, so including battering and banks to reduce the grade and riparian planting, will be provided in the Habitat Enhancement Management Plan. Land area to undertake enhancement is limited due to landowner restrictions. Currently available areas have been identified as the bank areas along the main stem of the Tiraroa upstream of the gates, is mostly limited to the right, true right bank. The tributary on the true left bank downstream of the gates. This tributary was chosen as previous investigations into potential Inanga spawning areas in Southland rivers highlighted this location as having a salt wedge. There is currently a perch culvert on this tributary, which is proposed to be remediated to improve fish passage at this location as well. The ring drain downstream of the gates was selected as an option. It is Environment Southland land that can be accessed near the gates with potential to be modified to provide for native fish habitat. I agree with Ms. Bowen that the ring drain downstream of the gates in its current form is not suitable for Inanga spawning enhancement. It was intended that alteration to the outlets would be required to improve native fish habitat and potentially Inanga spawning habitat. However, considering the changes to the outlets that would be required and the proposed new tide gate mitigation, this option's been removed from the list. There's two more. In paragraph 67 to 68 of Ms. Bowen's evidence, she discusses the mitigation offsetting proposed in the mitigation options report and how that compares to what is being currently proposed. A smaller area of compensation habitat has been proposed outside of any consultation occurring. This is because of landowner and budgetary constraints of the council. I agree that further detail is required. This is proposed in the enhancement plan. In summary, the proposed mitigation and enhancement outlined in table 1 has been accepted by the applicant and now forms part of the application. In my opinion, the proposed aquatic compensation will improve the current conditions for Inanga spawning and native fish habitat, but like-to-like compensation cannot be provided for in the system. The proposed habitat enhancement undertaken as part of the enhancement management plan in conjunction with the mitigation in table 1 will provide an improvement to fish passage and habitat values impacted by the tide gates.
Thank you, Ms. Drummond. I did have a lot of questions for you, but I'm going to try and keep them reasonably brief given the time constraints. But firstly, can you explain to me how, well, council referred to it as a cat flat, the fish gate. When he referred to it as a cat flat, is it what, does it come up and push it over?
Fish just tap, no.
How does it work?
I can provide, there's a really good summary of it being used recently by Environment Canterbury and the Taranaki River.
I think I read that because it was attached to someone's evidence.
Okay, so basically the idea is if you have where there are restrictions on what you can do, we have to come up with, you know, alternate examples and be a bit creative, and they've done that in Canterbury, and it seems to have been to quite high level of success from the monitoring. So you have a gate, and potentially it can be done on retrofitting gates was the recommendation, but it's basically so say you have a rectangle gate and then you have a smaller rectangle within it that would be below the water level, and that is open, so it provides free passage through a smaller aperture, and then the fish are able to move through it.
So it is open all the time and they can see it and pass through.
Yes.
And how much impact does that have on the?
It will have an impact, but not to the same level as having all three of the gates open, you know,
Okay.
for the time. So I do think it will have some form of impact, but further investigation will need to be done to confirm the size and the inundation and that sort of thing.
And these the current design of these gates, can they be altered to get them, as they can climb with their
Yes.
sucky mouth, but is there ability to redesign those gates to actually address that issue?
Potentially, I had considered that as part of my original evidence, and that would have been a great thing about doing consultation, to be able to look at what kind of alternatives and options that could be done. They can climb amazingly well, and I'm sure you're aware of that, but it's the firm edge, that square edge on the top of the gates, that they can't keep their suction over it, so they lose their suction and fall off, which is a shame. But there is potential perhaps to alter that, the top of the gate, to provide a smoother surface, and that could be investigated as well.
And I'm assuming that the boulder works, etc., short of widening that channel, so that's how you deal with the velocity. I guess how effective is it with the small fry?
Yeah, the data I have, in my opinion, doesn't show that velocities in the channel are a major impediment to fish movement. There is a certain time when the gates first open that it is faster, because you're having that rush of water from upstream moving through the system. But at slack tide and on small incoming tides, there is no real velocity barrier. But I do acknowledge that there is a temporary one when the water's flowing out. So having those boulder clusters, they would have to be designed in a way that they enable fish to move from one to one to move up. But yeah, it's not 100% certain how effective they would be during those higher velocity moments, but they would provide refugia and resting zones for them to be able to hide in until they could move upstream when there wasn't the velocity issue.
And have you seen these work before in operation?
No, this is just something that has been come up with to respond to the issues at the site specific, because that will not work here because it is too deep. But there is potential to look into other options, as Ms. Bowen said, about fish pathways.
So those boulders, are they likely to accumulate sediment or anything like that? And if so, does that impact on how they might operate?
That's where they were placed within the channel would have to be carefully considered. So I wouldn't put them in the main thalweg of the channel where the fastest velocities are. I would put them along the edges, and there would have to be maintenance associated with them.
And the salt wedge seems to be very important, because the way I read your evidence is that it's kind of on the limits of the salt wedge where this spawning occurs. And I'm trying to get my head around this, because it's a very productive whitebait fishery down, but the adults live freshwater upstream. So the habitat above the gates would actually be quite important, because that's where the salt wedge goes.
So to clarify, there's two main issues with Inanga. So you have the migration upstream, the whitebait run, which is the juveniles moving up into the fresh waters, so that they are impacted if they can't get through the gates. If the other issue is the adults they move downstream from the fresh waters, and then they spawn around the salt wedge. So that's just where the salt and the fresh water interacts. There's a zone around that, and each river is different of how far that extends, of where there is suitable habitat for spawning. And that relates to a lot of things, the water chemistry, also the inundation of the water moving up and down and keeping the eggs moist. So identifying where the salt wedge is quite critical, and all previous knowledge was that it was below the gates. So in that case, if the fish couldn't move down to that location, then they would be able to get to the spawning grounds. If it's upstream, they can.
Well, that's kind of why I'm asking, because it's quite a productive fishery from what I'm told. So obviously it is working at the moment.
Yes, there's likely spawning grounds upstream and downstream, and we did do surveys of both, and I can share all of that data. But you say it is a successful whitebait fishery. Those are the inanga moving upstream, the juveniles. That doesn't confirm the success of what's happening with the adults in spawning. They're quite separate issues.
Oh, so do they not come back to where they were born, so to speak?
not as much as some other species.
Yeah, that's where I was trying to make the kill. I thought
Yeah,
they
it's-
were
it's a
coming back
very
to this,
complicated
like
species.
a lot of fish too, so
Yeah.
that could be just random. That they just turn up, so here's a good place, so,
Every river is quite different.
yeah, okay. Well, that's interesting. The other question I had is, I kind of touched on it with Mr. Young, if the gates are taken away, there's a lot of work has been done on habitat mitigation downstream of those gates. So the way it obviously works is that that area is probably inundated for a greater period of time at a higher level. So if they're taken away, what happens now, what would potentially happen downstream to the habitat that's probably over the last 100 years got accustomed to how it works now? Is there likely to be, would it be detrimental, or would it just be a settling in period to where it works out where the equilibrium is again?
Yeah, I mean, without knowing the volumes of water and having models to look at what the extent is, if you allowed that tidal inundation to go all the way up to Fleming Road, you would expect there to be a loss of the frequency, extent, duration of inundation in that area that's been retired and that is being restored. Because of there's quite a wide range of tide cycles in the system, so it would likely still get inundated at periods, but there would be, it's not really within the scope of what I've looked at, but it would change, but whether
Is it
it's
a
part of
relevant
natural
effect?
cycle or not.
Is it a relevant
Well,
effect I should be considering?
It's a relevant effect in that Environment Southland has spent funding and efforts into doing restoration in that area. I don't know how adversely it would be affected though. I can't really give you an answer.
Just see if there's anything else important. There was a question that was in your evidence in section 33 where you talk about the migration upstream being triggered by stream discharge. Now, I just had a note there, meaning with a question mark. It's like, so.
So you're meaning
Is it-
for Kanakana?
Yeah, I
Or
think it was
anything
for,
that
in
you-
relation to the Kanakana, and it was, so how does that work? Is that an increase in flow downstream triggers the sensory whatever to, right, we need to move upstream? What is the
It's my
importance of it?
understanding. There was a response to that in Ms. Bowen's evidence where she did comment on that as well. There is literature out there that talks about kind of migration being triggered by increases in stream flow, but there is also evidence in systems where that does not occur as well. So they're a very elusive species and not much is known about them, so they're quite tricky to pin down.
The reason I was asking you that is because of that diversion channel up the top, and what would you expect the effect of that to be on Kanakana's?
I would say that the diversion channel has changed the hydrology of the system. It's not a natural system and it has been changed hydraulically. So you don't have the same, you do have the same floods coming through when it rains. It's not everything is going down that cutoff. But it's impossible for me to say what the natural conditions would be.
Yeah, I think you also mentioned that diversion channel, it might have been you, that also provides a.
It potentially could, potentially.
Yeah.
But I'm not sure. I haven't visited the outlets and inlets of that diversion channel, so it could provide an alternate migration path. But I also know that the gates are open half the time, so technically kind of can move through them when they're open.
Yeah.
And that has been, they do get through these systems, but it's not the free open passage that would be there if the gates weren't.
What do fish do when they come up to a barrier like that and they go, I can't get through? Do they hang around and wait, or?
Depends on the species. So the ones that have that kind of homing beacon to get upstream, they will hang out and wait.
Then they're subject to more, subject to more predation when that happens, of course. Yeah.
It depends on the conditions and the species.
Yeah. Okay, well, thank you very much. Your evidence is very constructive and helpful, as was Ms. Bowen's, but maybe a further discussion between you two later on. Did you have any questions or clarifications?
Just some quick ones. The rock refuge areas, will they be along the entirety of that channel or just in front of the gates?
I think further velocity surveys would help inform that. From the velocity evidence I have, the load profilers, you can see exactly where the fast bits of the flow are, so that if we did a few more of those, it could help inform if it's needed further downstream. And from what my understanding is, that they would be concentrated in the area downstream of the gates. Yes.
The letter blocks option for letting fish pass through. As the head difference increases, there'll be more water trying to push through. Would that pose a risk to the fish trying to get through there if they push more onto the edges of the letter blocks?
The moving upstream.
Yeah.
Potentially, that's where you put it and how it was placed would be really important, and that's where we would be relying on a fish passage engineer to look into that. It's the letterbox idea is really a solution that's been adopted in a complex area site. We're trying to work out a solution, and it's just been proven from what I've seen to be quite effective, because you can very clearly quantify what's getting through it by being able to put nets either side of it, whereas having them open a little bit longer and doing surveys up and downstream, there's quite a lot of interpretation.
Design stuff is a bit further on.
Yes. Yeah.
Well, the last one was we've heard uncertainty about the effect of the tide gates on the salt wedge. And so if we imagine that they were there, we don't know how far they would be. How confident are you that the area of spawning habitat has been quantified, as an effect of the gates? But what I'm trying to get at here is the offsetting, whether the offsetting overcompensates for the loss of the habitat.
Yeah, and that's where in the original mitigation options report we quantified the amount lost. So I have the length in kilometres, and then we looked at the bank height and things like that. I'm comfortable that it has been quantified correctly. I don't feel that there is enough land available within the area of potential spawning to. So the complicated thing is, if you change the gates, then the salt wedge completely changes, right? So if you leave it free open, the salt wedge extends how much further upstream? That's an unknown at this point. So your salt wedge location, and therefore your spawning area, would change. So where I said it was a conservative assessment is because I've considered that whole.
That's what I was trying to get at.
Yes, I've considered that whole reach. So I, in my personal opinion, think I've overestimated the area.
So that's independent of where the salt wedge might really be.
Yes, if you looked at just where the salt wedge is currently, it would be much smaller.
Thank you. That was what I.
Great, thank you. Mr. McSorley, I understand. Just before we get on to Luke, Ms. Blair, morning, Mr. Funga. Well, almost afternoon. We have an issue with dock timing, obviously. So I'm wondering if you good folk might see fit to go after dock. Is that going to work for you guys, or have you got some other constraints time-wise? Because we could take Ms. Bowen just out of order, I guess. That'll work. Right. Thank you. We'll probably have a short lunch break to try and accommodate anyone. All right.
Thank you for accommodating.
Mr. McSorley.
Thank you, Mr. Commissioner. So, having listened to the discussion this morning, there were a couple of things that I could quickly clarify.
They would probably be questions, so it'd be helpful if you did that, so I don't have to ask you them.
So there was a question on the option of removal of the tie gate infrastructure and what consents would be needed. So I think that that option would definitely require resource consent. The rules that I've had a look at, Rule 11.5.3 of the Regional Coastal Plan, which relates to removal or demolition of any non-piled structure. I think it'd be fair to expect that will be triggered. In terms of the proposed water plan, I think Rule 71 would likely be triggered, which relates to channel realignment, widening. And then I think there's the diversion of water in the CMA and the diversion of the water upstream of the gates would likely trigger rules as well. So the key thing is I think it would require resource consent. A lot will depend on the engineering and the methodology, but I'd expect that that would require resource consents under various relevant plans.
Yeah, but it's open for me to decline, which would mean the gates sit there until you get your consent, but the gates would have to stay open the whole time, wouldn't
In that scenario, potentially, yeah. Just the second point, so there's some questions around the definitions of infrastructure. And I think that there's sort of a question around the fact that it doesn't currently have a resource consent, whether that undermines its position as infrastructure. I don't agree with that, and in my opinion, I think the Weir and Tie Gates meet the relevant definitions of infrastructure. I sort of highlighted that in my evidence. There's various definitions through the RPS.
I think I've seen one that refers to flood and drainage works undertaken by the council as strategic infrastructure, so it's probably gets in under that clause.
Yeah, I think there's actually multiple pathways that under various documents. So I just want to make that clarification. Just moving on to my summary, which has been tabled, and my rebuttal evidence. In my original evidence, I noted uncertainty on cultural effects. So I've read the evidence of Ms. Blair and Mr. Whanga, and it said that the activity is having adverse cultural effects. Let's discuss paragraph 1 of attachment 1 of my summary. The rebuttal evidence I provided also outlines my revised position in regard to, I guess this stems from the recognition of the cultural effects that then affects my assessment, some of the statutory assessment in particular in regards to the policies of Te Tangi, so I've covered that as well. I've also provided, but they'll be spoken about a bit this morning already, draft conditions. These include the additional mitigation in relation to fish passage in terms of the letterbox option. The conditions also provide the monitoring of the proposed habitat enhancement and reporting of that, and that's been spoken about as well. So that's just the clarification matters. Just turning to my summary, just a slight correction at one of my summary. I've missed out the words and the relevant statutory framework in the first paragraph of 1. So turning to the environmental effects, obviously I've just acknowledged the acceptance around the cultural effects. I think the key thing with the effects is the wide range of effects that are relevant here. That includes the positive effects and adverse effects that would arise if the gates were removed, the positive effects of their function currently, the adverse ecological and cultural effects. So it's sort of a wide range of effects that need to be weighed up and considered. That then sort of links into the statutory framework and my assessment of that. I think again, there's a wide range of provisions that apply, and there's a bit of a tension between some of the competing policy provisions. I think Mr. West summarised that well in his 40, noted that in his 42A report. So I think the key thing for me is I don't think it's appropriate to have a narrow focus on any one of those particular policy provisions. And I think you have to take a wide view of it and assess it under all the relevant provisions. That's the brief summary. Thank you, Mr. Commissioner.
Thank you, Mr. McSorley. Yeah, I take your point around the definition of the infrastructure. Excuse is what this particular piece of infrastructure is doing when you deal with natural hazards as defined in RMA 51 and 52, and it's whether these gates are actually dealing with a natural hazard or just a natural process. When you look at, I think Ms. Ferguson's evidence highlights policy 1 of the New Zealand Coastal Policy Statement, that tells you what a coastal environment is and how it operates. And these gates, to me, appear to be restricting that, I guess. So the question that flows from that is, do the natural hazard policies have any particular relevance, even though this is part of a wider flood and drainage management work? Do those specific hazard policies actually have any relevance?
I think they do have some relevance, but perhaps it's not that strong. And Mr. Young sort of talked to that earlier today.
Yeah.
Covers it in his evidence. So yeah, I've noted that, but I guess I haven't gone too over the top.
Yeah, well, I'll hear probably from the other planners on that particular issue too. You would have heard the discussion around how the operation of these gates, and I don't know if this is correct, but possibly enhanced areas downstream or areas that have been enhanced downstream, and raising the water levels for longer periods may have a positive effect. I don't know if that's correct or not, but if is that part of my consideration in terms of the benefits of these gates? While it might have an adverse effect upstream, it's having a positive effect downstream.
Yeah, I think it would be.
I guess the problem is, what is that effect? What's the scale of it? Is it real?
So you're talking about
Yeah, gates removed.
Yeah.
There might be a negative effect on what's being done below them. And I've had no evidence on that, so I don't know whether there is an effect in that sense.
Yeah.
That's maybe something that I might ask for further information on, actually.
Well, I guess whether the fact that activity would need resource consent in itself, I guess that's the process that enable that sort of assessment to be undertaken.
And a lot of your assessment of the objectives and so forth, and I'm just focusing on one here, objective 19 and paragraph 109 of the water and land plan. It's about the passage of fish being maintained or improved. It's how do I assess that in the context of something that is currently not consented, so it's illegal. So I have to assess the environment as free passage through there. Granting consent to this would actually probably not maintain fish passage, or do you read that as a bit of a spectrum of how you maintain?
Yeah, well, it's been a problematic issue right through this. I guess I would note it's sort of not the classic scenario where someone's gone and undertaken an activity without consent,
Yeah.
and is seeking forgiveness after. I would read that policy a bit wider, going back to, I guess, the evidence of Ms. Drummond, Ms. Bowen, and noting that, yeah, obviously there's further mitigation now on the table.
Well, if it was still legally protected by the Act, you could argue it's been improved by the
Yeah, well, that's
the
right,
levels, but the problem is it's not.
no,
Maybe something Mr. Thompson addresses in reply. Tangi, you would have heard my question to Mr. Thompson. The elevation, given this is a statutory acknowledgement area and the significance of this to Runanga, how do you, when you come to assess these things, do you place more weight on, or is it just one of the matters, or do you place more weight on, in a general sense, in iwi management plans that have specific policies in these areas?
you know what, it needs to be have regard to, and I've spoken about having regard to all the relevant provisions. My understanding of the stat acknowledgement, you know, it's there in place to signal the importance of that area. I'm not sure it elevates. I'm not sure that's its function in terms of the planning process. So yes, I guess my answer is I think Te Tangi needs to be had regard to, as do all the other relevant plans.
Well,
and
the Act,
policies.
the Act say it uses the words, but it's just when we get into conflict with various policies, maybe does that particular plan give them more weight in areas where there's conflict?
Well, in this situation, we've got, I've acknowledged the cultural effects, and then also acknowledged that it doesn't align to a number of policies of Te Tangi. So that's probably the way I'd frame it up.
Okay, well, I'll leave it at that, but as I indicated earlier, there's possibly going to be conferencing amongst the planners in relation to how this potentially could work or not work. But I'll just see if there's any questions or clarification from you, Mr. West.
Just like to ask around clause 3.24 of the MBSVM and the provisions around the effects hierarchy. The government's provided information about the spawning offsetting to show that the compensating factors there are more than the loss in her estimation. What about the other values, particularly cultural and spiritual values? You've mentioned them, and you're just like you to sort of lead me through the effects management hierarchy we're supposed to go through.
Yeah, well, the hierarchy obviously firstly seeks to avoid, then minimise, then mitigate. So for those effects around spawning, fish passage, I think we're landing at the mitigate. In terms of the cultural effects, yeah, you can't land in that position where it stands.
That was really all I had to ask.
Okay, thank you. Thank you, Mr. McSorley. Mr. Thompson, anything to add?
No, thank you. I'll reserve it for any.
May come in writing. at some-
Yeah, I will
some
be
later
asking
stage.
questions.
Yeah. It's almost 12, and we shuffled the order. Mr. Pemberton, what time is 1 o'clock? So you come back?
1 o'clock's fine, yeah.
Yeah, that'll work. And
I can give Ms. Bowen a heads up and she can get in the room and feel prepared by the time I start my submissions.
maybe give her a heads up on questions of interest around how these things are, or the questions I've asked Ms. Drummond, and she can perhaps address those, and we'll try and move a bit quicker in the afternoon if possible. So yeah, okay, we'll adjourn to 1 and come back with your team. And you got Mr. Ferguson, are you based in Central Australia? Are you based here?
Oh, no.
You're here, so you don't have to get away. I was just concerned we're holding you up as well. Okay, thank you, folks. We'll come back at 1 o'clock with Director General. Thank you. I have a copy of your legal submissions. So given we're a little bit behind time, and I'm assuming you're probably just going to talk to the key parts of these rather than read it.
Yes,
all out.
I'll- that was my plan of attack, so
Yeah.
just to highlight key points.
I'm in your hands, thank you.
You, Tēnā koutou katoa, Commissioner, Environment Southland, kia marama, ka haere mai nei tere whare, ki te ako e ngā kaupapa. No whakatua hau, ko Matt Pimpton tuku ingoa, ki whakatua hau e Nokwana, ki te papa hau e mahi ana, ki roe te tau taku mahi, no reira tēnā koutou, tēnā tātou katoa. So I'm just going to start with the introduction and relevant background, and that's, I think, important to highlight a few points because it gives context to DOC's position in respect of the application. So paragraph 2, the Commissioner is already aware of the previous application, and I don't want to go into too much detail other than to note that DOC's submission in respect of that application in 2015 sought that the application be granted for a term of 5 years, during which time the fish survey should be completed, and if necessary, the tide gates he decides that fish passage was not impeded. That consent grant in 2015 provided condition 2 for a fish survey to include at minimum a comparison of fish communities upstream and downstream of the structure, an assessment of the flow profile, and the salinity survey of the Titiroa River to determine the upstream extent of the saltwater wedge. And a copy of that survey was forwarded to the Consent Authority and to the Department of Conservation. So that fish survey was not completed, and as outlined above, the resulting application was made after it had expired. So, as you're of course aware, the applicant is operating without a consent, having not complied with important requirements of its 5-year term of consent. And just noting there at para 6 that we received a copy of the fish survey when the application was notified in March 2021. I just want to address that the procedural issue I alluded to at the beginning of the day, which was to add to that further context. At 4 o'clock yesterday, parties received an amended proposal, including consent conditions from the applicant. All submissions and evidence filed by DOC and other submitters were made in response to an application being for the status quo with no conditions of consent provided until the day before the hearing. This should have been made in my submission 4 years ago before expiry of the old consent, or at the very least, it should have been made months in advance of this hearing to allow parties time to properly consider the amended proposal and comment on the consent conditions. So that's the crux of the procedural issue I'd like to raise, following on from the background that I've outlined. And I know you're an experienced commissioner, and perhaps you've been in situations like this before. I certainly haven't. But what my request would be that at the least that interested submitters have the opportunity to provide comments if they wish in relation to the amended application. And that would include Fish and Game, who weren't able to attend today, because we just simply haven't had any time to consider it. So that's the starting point.
In that context, Mr. Pemberton, would the joint conferencing act in the same way? Or?
I think, yeah, I suppose on that point I agree with Mr. Thompson and where your thinking is in that regard, that joint conferencing is part of the picture and that would be helpful. But I also think that submitters should that could be one part of the solution, but I also think submitters should just have the opportunity to be able to provide a written response if they wish to you on what they think in relation to this amended proposal, because there just simply hasn't been time for that consideration. That's my view on that. I agree that a conferencing would be useful, but that seems to be perhaps a bit further after that.
Could be a two-stage process in that sense. Yeah.
So moving on to DOC's position. So DOC's position sought that the application in its current form be declined. And having considered the available evidence, DOC supports Mr. West's recommendation that the application be declined primarily because of its adverse effects on river passage and inland spawning. I just note that DOC's position closely aligns with that of Fish and Game and Te Ao Marama Incorporated, and just that although Fish and Game have not been able to attend the hearing, DOC supports its detailed written submission. And just a few points from having reviewed the submission and evidence of Tami, there's alignment in relation to fish passage and detrimental effect on inland spawning. In relation to DOC supports that Tami's submission that the application does not put the health of the water body first and is inconsistent with the principles of Te Manawa Te Wai, and also that the application is inconsistent with an integrated management approach to Ki Tai. So moving on from that, I've set out some options available that I perceive are available in these circumstances, and I know you're aware of all of your options, but I think even having heard the dialogue today, I will just start commenting briefly on a few of these. And I think, well, conceivably moving forward, your options really are in the realm of options 2 to 4. So, and I know you've had some kōrero today around option 2 in terms of adjourning the hearing for the applicant to provide further information. Conferencing could form part of that picture. I agree, but I also think submitters first need the response to provide proper written comments in relation to this revised application to you and whether their position has changed from from the application as notified. And there's other, I know you're considering other information you'd like from the applicant, and I'll touch on that as I move through the submissions with at least where Doc's thinking is in terms of how that might help you with your thinking.
So in relation to that option, Mr. Pemberton, you'd probably be suggesting it's an adjourn further information while your team and other submitters assess what's been given. Then perhaps the next stage would be joint, and then it would actually be a reconvened hearing to consider that. Or
well, yeah, I mean that is one option. Yeah. I think so. Yeah. I mean, I don't know how you'd otherwise do it, but I do think, I think procedurally, because I'm just being honest, I haven't been in this exact situation before. I've been in the situation where an amended application was given months before the hearing and all the evidence could be tailored towards it, but this is somewhat different. So I'm just trying to think pragmatically about what could happen.
Unfortunately, most hearings are involved in the proposal changes in response to evidence it's heard.
Yeah.
So this is not uncommon, but I take your point because it's a complex situation we're dealing with.
Yeah.
And what would put, my friend Mr. Thompson maybe have to correct me here, but generally, if we were just doing joint witness statements, I may not necessarily need to reconvene because I'd be doing it on papers because you either agree or you don't, and there's but in this case, depending what came out of that, probably a
and I suppose
reconvening might be appropriate.
Yeah, for Doc's witnesses, if you're looking at planning and ecologists, then Ms. Sycamore and Ms. Bowen would be available. But I'm also thinking and conscious with where would that leave Tami and
they would definitely be involved in any of that process.
Yeah. I mean, as another option, just parties, because I can give you, I can give you, despite we've only had since 4 o'clock yesterday, that Doc's position in respect of this application on these consent conditions, which allows for a cut inside the gate of unspecified size, hasn't changed. So I can tell you that we're still seeking decline despite learning this information. But it's just whether for you it would be beneficial for parties to be able to provide, for example, some more comments detailed on the on the consent conditions and other issues, which frankly, since 4 o'clock, we haven't been able to have much time to do. That's the issue.
I took Mr. Thompson's offer to a conference before this as a way of probably potentially, and it doesn't mean your position is still to seek decline, but if it were to be granted, there's an agreed set of conditions, and we're not in that position. So I'm just going to let Mr. Thompson actually respond to that. Is that how that was the aim of that, was something along those lines? Or
Yes, that's right. It was intended to move things along, like you, including sometimes sitting in Mr. Pemberton's seat. My experience is things do change at the last minute, particularly with the tight turnaround with the evidence being exchanged shortly before the hearing. Look, I've just got no issue at all with what Mr. Pemberton's suggesting. It's reasonable and will help you. People want to have the opportunity to provide some written comments and then have conferencing. I don't have any, I don't seek to be heard on that. I have no objection whatsoever. Neither does my client.
You're clearly a lot younger than me, Mr. Pemberton. We used to do hearings when the evidence was all presented on the day, so you had no idea what was coming. So it is a far better process in what we've just discussed. That has been my thinking coming into this, and I really haven't sort of changed on that. So I'm thinking it's possibly where it will head. So because it's a significant issue, and I understand your client's position and the local room. They need time to digest this, and I think considering that and then working with the applicant if there is a way forward. That does not mean you have given up your submission to seek that the whole thing be compliant, but I'm still not clear 100% on all these things myself, so that
And that's where I suppose with this option too, I mean, if I may keep moving forward, I do think there's further information that's required for you to decide if the gates are required at the present location, and I've just outlined there some suggestions that Ms. Bowen has, and I think that is one, the thing that's positive about that is the level of consensus on many issues between Ms. Drummond and Ms. Bowen. So, I think that's in terms of where we see the positive of what's happened is that. But she's provided some suggestions, and then I just also note the suggestion Mr. West had made in his Section 42A report. And I just note there that he actually raised some quite broad issues, which I'm going to touch on as I move forward, which is perhaps the first question to ask is what, and I appreciate you've spent a lot of this morning trying to get your mind clear on this, and I'm not quite there yet. But is like, what is the actual necessity for the infrastructure as the first step, in terms of then it feels like we're getting into the detail of the type of gates, line, etc., and with consent conditions, but just taking a step back, and I know you're grappling with those issues, having listened to this morning. I'd just like to keep moving forward to para 17, just making the point that before Ms. Drummond had provided her evidence, the position had been that there was no impact, or less than minor impact, on fish passage, and no attempts have been made to mitigate this effect specifically. And just noting the evidence of Ms. Drummond and Ms. Bowen is that fish passage and Nuggets Warning are detrimentally impacted by the structures. And as you're aware, this assessment of alternative fish-friendly tie gates has not been considered until the last moment. So I will keep moving forward to the next part of my submissions in relation to the structure. And I don't want to spend too much time on this, but it does seem at least important to me to make sure we're calling the structure the right thing. And in my submission, just looking at the definitions of weir and dam, it appears to be, to me, that this is actually a dam and not a weir, primarily because it doesn't allow water to passively flow over the top of it, and in fact acts as a damming structure and is only overtopped rarely in flood events. So I've come to that conclusion. I've asked Ms. Sycamore if that changes the activity status, and I understand her advice is that it's still the same, and so this might not be a big issue, but I do feel it's important to at least characterise the structure as what it actually is, so we can be ensuring that the right policies apply to it and the right the right framework is applied. So I mean, whether that's something again you might want clarification from the leaders or Mr. West around, that was the point of that. So moving forward, again, I'm not going to waste your time with the adverse effects or much of this legal context of Section 104 matters, but I'll just turn to the environment because I know there's been some audio around that interesting discussion this morning. And I'll just note it there at para 32, Mr. West's view is that the tide gates and weir are not legally occupying coastal marine area nor legally damming and diverting flow. And he refers that the environment should be imagined as if the structures were not there. I agree with this statement, and my submission is the environment, for the purpose of your assessment, isn't what is physically there at the moment. It is instead the stream imagined without the tide gate structure, the dam or weir, whatever it is, and diversion channel being there. So as if the stream was interrupted by the unconsented activities.
So that would have to apply downstream as well, wouldn't it?
Yeah, to the extent that's within the effect,
Yeah.
yeah, I think that makes sense. But again, I think, so is this coming to what you're talking about, the surrounding environment?
Yeah, and it's, is it a positive or a negative
Yeah.
downstream if, because the environment may have adapted to what's there now, so the good work is being done downstream,
Yeah.
potentially maybe and I don't know if that's true, but that's something that I will be asking
Yeah,
and conversing. And so do I have to say, well, there is going to be a negative effect downstream, well, the environment downstream is going to be different as well. And also you would have heard the questions around the tile drains,
Yeah.
which aren't a part of this, but clearly have improved that land. So where I'm getting to with that is that past land is probably legally better than it would be. Putting that right. I can't go back to pre-gate conditions completely because the tile drains have
Yeah.
operated, but I don't know where that sits. And Mr. Thompson's made submissions on that, but I was wondering if you had any view around that. I think he suggested the environment's what it is at the time I consider the application.
That was what Mr. Thompson's
Yeah.
submissions were. Well, are you talking about in terms of their relationship with the type, the drains?
Yeah, and how that affects the pastoral land,
Mm.
which has been developed because of the
Yeah.
gates, I guess, but there is the elements of the tiles, so it's very vexed, this whole thing.
Yeah, I mean,
You're scratching your head,
I'm
that's what I'm
scratching my
doing.
head with this too, so I mean, I would have thought that those, those the drains, as I understand it, are in a response to the water level in the soil, which is a result of this structure, right? So that's why they're there. But I just don't know how that can be provided as, as your view, the existing environment should include those. Is that what you're saying?
I don't know yet,
Yeah.
that's where I'm trying to get. How do I divorce them from the operation?
I mean, my submission is they shouldn't be relevant for your determination of the application, and it should be focused on if these activities weren't there, what would the stream and surrounding habitat look like? And I don't think you should then have to imagine, also take into account I mean, legally, I think you don't, you wouldn't need to consider those drains, but I get it from a pragmatic overall situation as they are actually there. And I mean, perhaps some of this is, again, goes to the further information you're going to need in terms of assessing, the level of effects. So sorry, I can't give you a really firm steer because I am scratching my head on that point too, to be frank. All right, so I also just note there in para 34, I think it highlights the importance of any conditions of consent providing for decommissioning. And I'm talking about the gates specifically, in the event consent being granted. So that's my understanding of normal and experience of normal processes in this regard. I know it's slightly complicated in the fact that there's the planning assessment is there, needs consent for the removal, but that's still my submission that any consent conditions should be provided for decommissioning of the structure.
So so what you're saying there, if I granted a 5-year consent, condition could be within at the end of that consent, those gates shall be removed. I'm legally able to do that.
Yes,
and the 5 years would be to sort out your leasing arrangements. And,
that's my submission, and perhaps a bond or surety to ensure that happens. So I'm going to move on to environmental bottom lines, para 37. And I just want to mention the Davidson decision, which is particularly relevant to the coastal policy statement, which I'm going to get into. The court stated that resorted to part 2 for the purpose of subverting a clearly relevant restriction in the NZCPS adverse to the applicant would expose the consent authority to being overturned on appeal. So, yeah, and I know you are fully aware of the interpretation of the directive avoid policies, avoid as being environmental bottom lines. And that is one thing I haven't heard any submissions on from Mr. Thompson, and I'm going to come to that a little bit later, about the environmental bottom lines which are at play in this application. So my submission, the outcome is where prescriptive NZCPS policies are engaged, consideration of part 2 is not required, and resort to part 2 to subvert a clearly relevant restriction adverse to the applicant would be contrary to King Salmon. If you find that it's unclear from the NZCPS whether consent should be granted or refused, you'd then be in a position when you need to have regard to the regional coastal plan. Recourse to part 2 would only be required in limited circumstances. My submission is directive NZCPS policies are engaged in relation to this application, and in particular policy 11. And following Davidson, my submission is that because the application subverts clearly relevant restrictions in policy 11, consent should be declined. If you instead make a finding that it's unclear from the coastal policy statement as to whether consent should be granted or refused, then it would be appropriate to consider lower order planning documents. My submission that limited weight should be given to the Southland Regional Coastal Plan, as even though it was made operative in 2013, all of the policies, apart from Chapter 15, marine farming, became operative in April 2007. So the plan has not been prepared to give effect to the NZCPS. So some objectives and policies may be consistent, others may not be. So if you do look at it, very little weight should be given to where policies are inconsistent with the objectives and policies of the NZCPS. And I just know it's consistent with the approach taken by the Environment Court, where Judge Jackson gave greater weight to the more recent NPS for UDC and the district plan. In terms of the weighting of other documents, in my submission, weight can be given to the regional policy statement because it was promulgated to give effect to the NZCPS. And many of the objectives and policies of the RPS are directed to the regional coastal plan, which hasn't been updated to give effect to either the NZCPS or the regional policy statement. And then just looking at, because I know, of course, and I've heard Mr. Thompson talk about the proposed soil and water and land, Southland Water and Land Plan, sorry. I'll get to that in a second, but I just make the point in relation to the NPSFM that the regional policy statement predates the NPSFM, so in the event of any conflict between the NPSFM and the RPS, conflict should be resolved in favour of the NPSFM. Weight can be given to the Water and Land Plan. I agree with the consensus about how it's essentially operative, apart from I understand one or two policies which aren't involved in this particular application. But I just make the submission there that this plan was proposed in 2015 and it doesn't give full effect to the NPSFM 2020. So it does to the extent that matters within the scope of submissions were brought into the NPSFM, and it gives effect to those matters, but doesn't give full effect, for example, in relation to Te Mana o Te Wai. So if you find any conflict between the proposed plan and the NPSFM 2020, it should be resolved in favour of the NPS.
I think what you've highlighted there is the need for planners to conference on how all of that, how they do relate and don't relate and give effect to and don't give effect to.
But I've also, I agree, but parts of these are just purely legal issues.
Yeah.
And I think the key thing that the applicant hasn't actually dealt with here in the application just is in relation to the New Zealand Coastal Policy Statement. So the tide gates and dam and weir are located in the coastal marine area. The NZCPS is engaged, and of course goes further, it goes into the coastal environment. It takes precedence over the regional coastal plan. You know, note the applicant's planner provided 2 paragraphs discussing the NZCPS, and Mr. Thompson fails to address the NZCPS in his submissions. And I think this is a major issue for the applicant, because I think my strong submission is if you find that the application breaches policy 11 of the NZCPS, it should be declined. So I just would move on. Para 48, I mean, you're aware of what a void means, not allow preventive occurrence of. In my submission, turning to para 50, if there are minor or transitory effects of policy 11 values, that may not amount to a breach of policy in respect to policy 11. So that's just consistent with case law. And para 51, just moving on, the evidence of Ms. Drummond, supported by Ms. Bowen, is that fish passage and inanga spawning are detrimentally impacted by the tide gate structures and the effects. This gets to the rub of what I've been alluding to in terms of policy 11A. It's a number of species classified as threatened and at risk as per policy 11A, and I've listed them there: inanga, giant cockapoo, and long fin eel, at least including those species within that policy. Effects are required to be avoided, and in my submission, the evidence is that these structures impact significantly on freshwater fish values and passage within the catchment. And yeah, just highlighting that's the expert consensus that's been reached. Then moving on, there's other directive avoid policies within policy 11 that have been in my submission that they are also engaged, and that relates to 11B2. The habitat surrounding the tide gates are important during vulnerable life stages of inanga, and habitats important to migratory species. Evidence of Ms. Bowen is that inanga usually spawn in close proximity to the saltwater wedge, but spawning can extend for some distance up and downstream. And I just note that seems to me that there's still uncertainty about where the saltwater wedge is actually located, because first we're told it was before it was located upstream of the gate from the information in the application, and then previous surveys which have shown that it was located below the gate. So my submission, although the precise location is unclear, the evidence is that it is located in close proximity to the tide gate structures, and just highlighting how the habitats surrounding the tide gates are important for inanga during this vulnerable life stage, which is when they're migrating to spawn amongst riparian vegetation. Ms. Bowen's evidence is what the applicant had proposed may not adequately mitigate against loss of spawning opportunity, and on the evidence, my submission is you can find the applicant has not demonstrated compliance for these policies 11B2 and 11B5, and I've outlined that gives you a basis to decline the application. And I'll also note, having read through the evidence of Tami, that if you agree with that evidence, that would support a finding of the application of breach of 11B4 in relation to avoiding significant effects on the habitats of indigenous species like inanga that are important for cultural purposes. And that would be, for example, through the loss of mahunga kai within the Titiroa River. I then just mentioned the precautionary approach, and I just make that point because it seems to me that on the evidence that the effects, perhaps as one finding you can make, is that the effects on inanga and habitat associated with inanga spawning are uncertain. If you make that finding, you could still, in my submission, say that the application results in a breach of policy 11 if you find on the evidence of potentially significant adverse effects of inanga and habitat associated with inanga spawning. So then briefly move on to functional need. And I spent a lot of time scratching my head about functional need, and then sort of came to the conclusion that is there actually a need for any of these structures in the first place, which I know you've been grappling with this morning in terms of questions. So I don't know if it's very helpful in terms of functional need definition within the CMA, because if there's actually a need for it, then I sort of get by virtue that it needs to be, the tide gates that would need to be in the CMA. So what I'm trying to articulate there is the question is, for mine, is there actually a need for these structures? And questions I had was, which I know you've been dealing with and made progress on this morning, include what land is at increased risk of ponding and saltwater intrusion if the gates and associated structures weren't there, whether the land could still be protected if the gates were only closed at higher tide water levels. And I know we've had evidence of, sorry, I forget your name. Mr. Gardner relating to the model around that, and whether other less invasive out-of-stream flood management approaches would be feasible to deliver some protection. So I just make the finding there that even if you found that there was both a need and a functional need for the tide gates, this does not negate the applicant from having to meet the environmental bottom line policies of the NZCPS. Moving on to the NPSFM, there's just three key parts I want to talk about. The first is 3.24 in relation to avoiding loss of river extent and values. So para 67, again, I just make the point that this is an environmental bottom line. The application, it's an avoid policy, must meet to be granted, similar to policy 11 of the NZCPS. The loss of river extent or values must be avoided unless there is a functional need for the activity in that location, in which case then you don't, in which case the effects are able to be managed by applying the effects management hierarchy. So I just make that contrast that it can be that policy 11 is NZCPS is an absolute avoid. This is avoid unless there's a functional need. If there's a functional need, then you just go to the effects management hierarchy. To make the point that it's no dispute these structures are having ongoing adverse effects on the Titiroa stream. It's natural tide processes, and this has been acknowledged in the application, and the effects on the Titiroa River by the structures are not being avoided. So, unless the evidence shows a functional need, as meeting the definition in the NPSFM, to be able, you should not consider the mitigation offset measures put forward by the applicant. I've just set out the definition there in para 69 of functional need. And then Mr. Gardner's evidence based on the model is that the area most indicated by the removal of the gate or alteration of timing is approximately 9 hectares of farmland that would be increased risk of ponding and saltwater intrusion, impacting on the soil quality and viability of the land for agriculture use. And again, I know this is an area you might want more evidence on, and I'm still not entirely clear exactly what that refined amount now is from Mr. Gardner's evidence. But I just want to point out what, as a submitter interested in the case, we've been trying to understand. The application first said the tide gates influence approximately 11,500 hectares of improved pasture. According to Mr. West, the 1986 application referred to drainage being affected on 1,150 hectares of land, and then contrast these different figures that we've heard from Mr. Gardner. So I appreciate it's based on a model. So I'm scratching my head, as are you, I'm sure, and I know part of your questions, you'll have further questions, and you've been trying to understand this morning. So moving on to para 72, if you were to find a functional need of the structures, then consistency could be shown if the effects of the activity are managed by applying the effects management hierarchy. And I agree with Mr. West that the offsetting of adverse effects on inanga by enhancing spawning habitat has not been demonstrated to follow the steps and requirements of section or policy 3.24 of the MPSFM. And just to, again, highlight a difficulty with trying to understand what's been proposed. The report in 2022, as a result of the further information request provided for 6.9 hectares of mitigation. Ms. Drummond's evidence initially talked about 1.4 hectares, and now from what we received yesterday, it looks like we've got 0.6 plus 0.53. But again, my question is, well, is there actually a need and functional need? Have you got through that? If so, then this new amount that we're hearing about as of yesterday, how does that follow the effects management hierarchy, and how does it apply? How does it comply with the principles of aquatic offsetting and compensation that are mandated in Appendix 6 of the MPSFM? So just want to keep rattling through. Te mana o te wai, I've made the point that my submission, it's a clear directive, which I know you're aware of, and in my submission, the application is not consistent with Te mana o te wai, and the evidence of Ms. Drummond and Ms. Bowen in particular leads to the conclusion that the health and well-being of water bodies and freshwater ecosystems have not been prioritised. Fish passage, so that was the third aspect of the MPSFM I wanted to talk about, maintain or improve. The evidence of Ms. Bowen is that the continued use of an outdated passive tide gate structure is not consistent with this requirement. And I know you won't be hearing from Mr. Christie, but his evidence is that he observed whitebait returning down the stream from the gates and the weir. And this highlights the barrier presented by the dam weir and the tide gates at odds with the requirement of fish passage in respect of these in-stream structures to be maintained or improved. Quickly about the fish passage guidelines, both Ms. Bowen and Ms. Drummond referred to those guidelines, and I know they're referenced in relation to what could be an alternative if you find there is actually a need for gates. You know, if you find there's a need and a functional need, then there's various options, and they've both referred to options available in the fish passage guidelines. And they, as I understand, state where the use of tide gates should be avoided, but where their use is necessary, automated, active or self-regulated tide gates should be used. My understanding actually is that these letterbox gates aren't mentioned as options in the fish passage guidelines, but that's perhaps something, I know there's actually a new version coming out, and that's something that perhaps is an issue for conferencing with if that's where you want to go. So I just made the submission that you can consider these guidelines as a relevant matter pursuant to section 104(1)(c). And so just briefly some comments on the officer's report. I've already said we support Mr. West's recommendation, and that it aligns with Doc's theory of the case. Doc also agrees with Mr. West that more information is needed regarding the beneficial effects of the activity, as well as the other matters that I've raised. Mr. West also states the previous consent was allowed to expire before the application was lost, which complicates and undermines consideration of the tide gates as existing and regionally significant infrastructure. So I know you're aware of this about how strategic facilities, and I'm not saying for 1 second that it doesn't meet the definition, because I agree it does. Yeah, it's clearly drain infrastructure managed by the council. The question I have, which I think is the same as Mr. West is asking, is that as drainage infrastructure that is managed by Southland Regional Council that is unlawful, does that fall within the definition of strategic facilities? And if you were to make this finding that unlawful structures, it's open to you to make finding that unlawful structures should not be RSI. I look at that definition, I think arguments can be made both ways, to be frank, and I don't have a strong submission on point on it, but I just think it could be implied that it's the council's having to manage lawful structures as an implication of that's what should be implied. But again, it doesn't say that explicitly, and I don't have a firm position on that. I'm just raising, I guess, highlighting the same issue that Mr. West has raised for your consideration. And then just finally, Mr. Westview, that the NZCPS is a high-level document and in general its provisions are not readily directly applied to individual activities. I disagree with this interpretation. As I've already mentioned, it contains directive avoid policies as described above. And I just note that the Supreme Court has held in the King Salmon case that although a policy in the NZCPS cannot be a rule within the definition of the RMA, it may nevertheless have the effect of what in ordinary speech would be a rule. I won't go, well, I'll just note with freshwater ecology evidence that in my submission, the application is clearly subverting clearly relevant restrictions, environmental bottom lines in both the NZCPS and NPSFM as I outlined above, and that gives you reason to decline. The planning evidence is that based on the application's current form, there is insufficient information available to make a decision on it. And the available information is that the application is contrary to policy within A of the NZCPS, and that there is significant adverse effects on river values, including fish passage and inung spawning that do not support the ability to approve the application. I won't go through part 2 of the RMA because I've provided those submissions just for completeness. In relation to conditions, again, I'm not going to go into any detail on conditions because we didn't have them until yesterday at 4 o'clock. I've made some suggestions there as pathways forward in relation to parties perhaps submitters being able to provide comments on those. So yeah, my concluding remarks is there's avenues that I've provided in option 3 and 4 for you to be declined the application in its current form on the basis of both effects or inadequate information, or the other option is, which I understand is providing for further information and conferencing could be part of that picture as well. And just really quickly, if just got a few comments on Mr. Thompson's submissions. Is that okay to make them? I just think now is the appropriate time. I think we've dealt with the existing environment and the head scratching that I'm having with that. So I guess all I'll say there is, do you have enough information to know what this existing environment would be like, which the effects of the application would be assessed against? That's sort of what when I was thinking about this last night, like how can you get that information? I mean, before today, I was thinking, is there any records that Environment Southland has of flooding in this area? But I think where you're getting to is, well, as I understand the corridor going, is that this is more drainage infrastructure, and I don't know if there's. I'm just trying to think pragmatically if there's any publicly available records that could, for example, assist in your determination. Para 51 of Mr. Thompson's submissions, he states in relation to Tami's evidence, if the answer to the question is what is the healthy state, is a stream with no gates, this shines a light on the task view, which is the classic balancing of competing values. On my submission, I disagree. You aren't tasked with balancing competing values. The question is, does this application breach environmental bottom lines? And at present, in my submission, the answer is yes. Para 52, he states, there's no policy support for a position that, taken to its logical conclusion, would require reversion of the surrounding land back to some historic state. Again, with respect, I disagree. The concept of te mana o te wai and directive avoid policies that I've mentioned provide that support. Turning briefly, Para 56, in relation to Mr. Gardner's model, at the time of writing, no party has taken issue with that model. I acknowledge that DOC hasn't, we haven't provided a modelling expert, and I've been trying to listen and understand this morning in relation to Mr. Gardner's evidence, but just make the point that when DOC made its submission, it noted that there was no modelling or other adequate assessment that had been carried out. So now it's been carried out through evidence. Now we have a model. We do have some issues which Ms. Bowen has raised, and again, questions front of mind are, does the model input only at spring high tide? If so, why when a range of tide scenarios at different times of the month used? And what about modelling different scenarios, including the removal of all structures, as opposed to just focusing on the tide structures, sorry, the tide gates? Given there are, of course, 3 activities that are being applied for consent. Para 67, the focus in these submissions is the proposed plan and the structure of the plan, which I understand Mr. Thompson's referring to the regional coastal plan. And I just point out the objectives and policies of the regional coastal plan should be given limited weight. And as raised earlier, there is no mention at all in relation to the NZCPS and environmental bottom lines, which I imagine Mr. Thompson will want to respond to in his closings. And then, yeah, I make the point, I've heard the corridor and around conferencing, and I think that as part of the picture could be a way forward should you want further information. And yeah, but perhaps there are also more fundamental questions you need answered first, like the actual necessity for these gates. Well, so yeah, that concludes my submission, and I know I've gone a bit over time. So,
that's fine. Thank you, Mr. Pemberton. Really, the only question I had, outside the ones we've already asked, but in paragraph 39, I was slightly confused there, where you say that if I find the NZCPS is unclear whether consent should be granted or not, Davidson says I should go back and look at the regional coast plan. I kind of thought that was the other way around. It's when your lower order plans have basically what you were saying that it does. Then I look at the coastal, go to the higher order document, because if there's a gap in those lower order plans, I need to just look at the higher order document. I wouldn't need to go back down because there's a gap. That's the only reason how that works. Right? Yeah. Did you kind of understand what I was saying?
Yeah, I get what you're saying, because on the one hand, I'm saying that the regional coastal plan was prepared before the NZCPS, so it shouldn't be given any weight. So this is, and I've cited the exact paragraph number where that's said, and Davidson, and it's Paris 72 of that Court of Appeal decision. So what that is saying is, you have a directive of void policy, NZCPS is engaged. If you find, which this is my key submission, which is if you find there's a breach of any of policy 11A or B, that is grounds for decline, and you don't even need to go to the regional coastal plan. That's what I'm trying to say there. If it's unclear to you, then you do go to the regional coastal plan. In this situation, I don't think the regional coastal plan is going to provide you with any guidance because it's actually prepared before the NZCPS. So then I'd say, well, you could perhaps look to the RPS, which was in 2017. You give that way. You have to look at whether they're competently prepared under the Act. So you go to that, and then if you still are unclear, only then would you go to part 2. But my submission is you just and I appreciate as well. And I've been trying to get clear in my head about this as well, because you have the MPSFM. So again, I'm saying there's avoid policies there. I think it's a little bit different because again, I'm saying that if you find breach of any of those directive policies, then consent should be declined. But I also acknowledge that the proposed plan, is relevant because it actually has to an extent been prepared to give effect to the NZCPS. But if there's any conflict between the proposed plan and the MPSFN, that should be resolved in relation to the MPSFN, because it's
One of the questions being exercising in my mind is, where does the coastal plan end and the FM?
Yeah, that's a good point. Yeah, so there's an overlap between there's an overlap between the two, because the MPSFM also applies in receiving.
Receiving, yeah.
Yeah.
So, yeah.
And it applies to all fresh water, so both apply. And yeah, but the key, and this is a key issue, and I'll say it again, but the structures are in the coastal marine area.
Yeah, the structures are, but the effects are.
Yeah, and then, yeah. So, yeah. And I guess that's the challenge before you, is to put these all together. I'm just saying, in my submission legally, both apply, and if you find, and these are environmental bottom lines, all these directive avoid policies have to be complied with. Yeah.
So the Port Otago decision has no bearing in this context, in your view?
In my view,
the
no.
material effect isn't relevant to the avoid policies, or there are no other competing directive policies?
So my submission, Port Otago is not relevant. That dealt with the competing directive policies in the NZCPS, where there was the, just find it now, bear with me. We're not in that situation of competing directive policies in the NZCPS. It's just whether, there's environmental bottom lines and it applies.
And just to confirm, I guess all these arguments are made in the context of what the legal environment is, i.e. the gates aren't there.
And that's what I think is difficult.
Because it's a different argument if they're legally there.
Well, the existing environment, that's the challenge, is to imagine without any of these structures there. And I also just would like to note one thing I've found hard in preparing for this is a lot of the emphasis seems to be on the gates. What about the diversion channel? What about the dam? Where's the existing environment actually is without those structures there? So has the model actually considered that? Would that be beneficial for you to try and understand that? I think perhaps it would be.
Okay, well, thank you very much for that, Mr. Pemberton. I'll just see is there any clarification from your side of things, Steve?
I sort of apologise because I know I struggle with this one as well. Same thing you've been going over the environment. Mr. Thompson made a point before about, I think it's paragraph 41, 42, that these gates were lawfully established. They did operate lawfully. Is therefore things like the pasture that's developed there, is that the existing environment, or are we reverting?
That's exactly your question, right?
Yeah.
And I'm just like really struggling to get my head around it. But what I would say is to try and that pasture's there as a result of the effect of the damming, etc., of these structures. So I think, trying to imagine what it would be like, which is what I understood the Commissioner was grappling with in terms of what it would be like if they weren't there, which would perhaps be, and also reading the lay evidence, it's talking about rushes popping up, it's moving into a wetland environment. So perhaps that is actually what needs to be imagined, is not the fact that pasture's there as a result of these modifications from the structures, but that perhaps what would be there would be wetland.
Yeah, I'm trying to get to they were legally there for a period.
Yeah, but that doesn't change.
You're taking it back beyond before that, or just back to?
I don't think it, even if this application was made 6 months before expiry in section 124, we would still be imagining them if they weren't there. The same test applies, because you only imagine them that are there until the end of its consent term. So I don't actually think it really alters assessment of the existing environment. It's just, you're still trying to imagine something, because that's the whole point. It's like, this isn't a land use consent which is granted forever. This is something that comes to fruition, it's finished, and you're trying to imagine the environment beforehand.
That was what I was trying to.
Yeah, and I think Mr. Thompson's point was about, yes, in the legal environment, these things don't operate. But what I think he is saying is that when this environment's been created, didn't need consent to create that, it was done, so that becomes legal. I think that's where Mr. Thompson was going. So you're saying, well, that couldn't happen without.
Yes, yeah.
But the point is, it has happened because they were legal, and I think that's where Steve was trying to.
But is that,
that's
is
what
that
I'm
a
trying to
difference?
I'm just trying to get the
Well,
opinion.
then does that
Yeah.
come into the permitted baseline? I don't know. Because, you know, if that's like it's a permitted activity, the permitted baseline is,
Yeah.
that's discretionary, you know? So if it falls in the permitted baseline, then my submission would be part 2, values are at stake, and you shouldn't apply the permitted baseline if that's where it is. But I just, you know, again, I'm just trying to, I'm thinking on the fly, because this is, I appreciate it as a challenging issue.
Yeah, and that is potentially a conferencing thing with planners. In knowing planners, there'll be various positions on that.
Yeah.
Okay, well, thank you, Mr. Pemberton. A lot of food for thought there, and we are slipping further and further behind. But I think, as I have signalled, that conferencing will be beneficial here. We might have to move through the witnesses pretty quickly.
Well, thank you very much. I'd like to call, hopefully Ms. Bowen can hear us remotely. And I've given, Commissioner, I've given her instructions. She's going to read just a brief summary and then crack into questions. So over to you, Ms. Bowen.
Great. Kia ora koutou, everybody. I hope that you can hear me okay.
We can, thank you.
Great, excellent. Yeah, well, hi everyone. My name's Jane Bowen. I'm a freshwater technical advisor for the Department of Conservation. I'm usually based down in Invercargill, but unfortunately couldn't be with everyone today, so apologies for that. Would it be a good time for me to read a summary of my evidence now?
Yes, thank you.
Great, excellent. Right, so the Tataroa stream is an important migratory fish catchment with the presence of threatened and at-risk fish species. And these species need to move between freshwater and marine to complete their life cycles. The Tataroa tide gates, dam and diversion channel all impact significantly on freshwater fish values and passage within this catchment. This is because it prevents the passage of fish when they are physically closed, which occurs for half of every tide cycle and would result in delayed migration, which comes with its own consequences. But there's also very likely impacts on passage of some species and life stages, even when they're open, due to that velocity which has been noted within that diversion channel. So in my opinion, all of those structures, so the tide gates, as well as the diversion channel and the dam, impact detrimentally on not only fish passage, but also on inanga spawning at this location. So as you would have seen in my evidence, all tide gates are considered barriers to fish passage. However, the Tataroa tide gates are an outdated passive design. So these open and close passively on the tide. The New Zealand Fish Passage Guidelines state that best practice is that when tide gates are required, obviously if they're not required, then the best ecological outcome would be for them to be removed. But if they are required, is installation of active gates, which only close once water levels reach a critical level. So for example, they could, could close on those high spring tide levels if it was really needed, but on lower tides, they might not need to. Then we've got self-regulating tide gates, which are considered the minimum standard, which hold the gate open for a longer period of time and allows greater fish passage. Reviewing the application and further information that the applicant has provided to us, I very much feel that there's insufficient information consideration or feasibility been given to assessing these other options or other alternative options within the Tataroa system. So I understand that to mitigate against the impacts on inanga spawning, the applicant proposed various mitigation or offsetting through habitat restoration. I have some concerns around the amount that has been proposed, and I also feel that there's very limited information provided on the location, methods, or even feasibility of these restorations. So it does make it very hard to sort of assess the appropriateness of that. So I provided recommendations in my evidence, and that includes that firstly, in an ecological sense, removing the structures resolve the adverse impacts on fish passage and inanga spawning. However, if the gates are required in the present location, then I've recommended full feasibility design and implementation of a fish passage design that is consistent with the New Zealand fish passage guidelines, taking into account the hierarchy of solutions for tide gates listed in those guidelines, should that tide gate structure being conclusively shown to be required. I also feel that there needs to be reconsideration of the area needed to be offset or mitigated against, and proper identification of these sites, as well as feasibility of the inanga spawning restoration proposed. Also further investigations in regards to inanga spawning, given the current inconsistencies and uncertainties that we have, and also monitoring reporting to further understand the impacts of the structure, and to ensure the maintenance long term, and to inform any subsequent improvements.
Thank you. Was that the end of your summary?
Yes, that's my summary. Thank you.
Yeah, well, thank you very much, Mr. Bowen. I did find your evidence very constructive and helpful. I'm not sure if you had a chance to look at Ms. Drummond's supplementary evidence where she's promoted some additional mitigation.
I have managed to have a very brief look at it. Yes.
Yeah, so including the letterbox approach.
Yes.
From memory, did you promoted that in your, or raised that in your evidence?
Yeah, I raised it as a potential option that could be considered. Certainly, I would say that the best outcomes would be, if it's not required for it to be removed, and then to move down that hierarchy of potential mitigations, which are in the fish passage guidelines. So with that preference being for active tide gates, or then you'd move down to that self-regulating tide gates, and then maybe look at some other options if those weren't appropriate. But I do feel that that consideration needs to be given to those options first. The letterbox, now Ms. Drummond might have some further cases that she's aware of. I'm only aware of one case where that letterbox solution has been used in Canterbury. They have done some monitoring in regards to that, and that that initial monitoring has shown some reasonable results, but it does need to be much more extensive monitoring carried out there to really sort of understand how good that is at providing fish passage. It is quite a novel solution, so yeah, would need a lot of monitoring around it. But again, I would sort of point to that hierarchy of options and investigating those first.
So when you say reasonable, what do you mean by that?
Well, initial results.
Surveys, yeah, have there been surveys upstream, downstreams, before and after? And what's the comparison there?
No, so Environment Canterbury, they, I believe it was them that carried out that work. So they refitted a tide gate. I think it was due to earthquake damage or similar. So they did some good monitoring in regards to looking at the fish moving through the gate structure. They used modified fyke nets through the opening. So it wasn't sort of just upstream, downstream, presence, absence. It was actually sort of looking at what species are moving through.
Oh, okay, yeah.
And very, very limited modelling to date. So yeah, certainly, I don't think that we have enough information to understand how good a solution that is at this point.
So your concern around the what you refer to the critical level of where these gates should kick in, and that needs to be modelled from your perspective. Have you been involved in cases where that's happened before?
No, I haven't. But in regards to active gates, so no, and again, I could, as I submitted in my evidence, I don't heavy expertise to critique the model. It was just a bit of my concern that the model had only included tide scenarios at the very highest tides that you would see in that system. But spring high tides only happen twice a month. What about the other times of the month? Do the gates need to close on every single tide? And that's why or active gates could potentially be used if modelling showed that at lower tides, the drainage network could handle that.
In relation to the dam or the weir or the dam or whatever it may be,
Sure.
in Mr. Christie's evidence talked about all the whitebait sort of going up to that and getting sort of trapped. What happens?
Sure.
What happens in that scenario where they have to backtrack? And do they eventually backtrack and go around, or how can that issue be avoided?
Yeah, so you're talking about when the tide gates are shut and obviously the dam is preventing any passage. What happens to those fish that cannot move upstream at that point?
No, well, in both scenarios, really. What do those whitebait do when they come to the weir? Do they stay there, or do they move back down and go into the diversion channel? Has anyone assessed that, or how do they?
No assessment has been provided by the applicant. I guess there's probably a lack of research in that space. And I mean, it would probably quite site specific too. I assume that the fish will mill around and eventually will presumably find the diversion channel. But yeah, I guess in terms of the sort of milling around there too, we know from the fish surveys which have been done that we've got perch and large eels downstream. So there's essentially a predation risk there, and also energetic cost for fish as well.
I'm just thinking ahead, if a suitable mitigation through the gate can be provided, then you can resolve that issue at the dam or the weir. Is there some way to actually enhance that? Because of the predation and those effects are probably quite significant if they're trapped there. It's keeping a free-flowing, moving tide of whitebait up the stream rather than having them trapped there. Are there ways to deal with that in the old channel to actually direct them in the first instance up the diversion?
Into the diversion when the gates are open, you're talking about?
Either or, because if we have a gate that allows them through, which is some through in the letterbox approach, what I'm trying to get at is there seems to be a lot that get stuck below the dam and mill around there, and as a result, predation takes place, etc. And that probably currently happens at the gates as well. But if they can be diverted straight up the diversion and through the gate, then that issue is sort of semi-resolved, I would have thought. Is there ways to do that in stream to direct them in the right direction?
I hadn't really considered that. I mean, obviously, when the gates are shut, there's going to be a predation risk no matter what, because they can't be, safely directed through that diversion channel when those tide gates are shut. So that's going to be an issue regardless. When the tide gates are open, and as Mr. Christie has sort of alluded to in his evidence, but obviously, swimming around and heading back downstream, and because as his evidence sort of alluded to, whitebaiters' net's been set backwards and so forth. I hadn't considered that, to be honest. That's probably something I would have to think about in terms of the risk there and how long it might actually take them to find the diversion channel and then successfully navigate the tide gates. But that's definitely a consideration that we need to take into account.
The other question I've been pondering is, if the gates are removed, what impact, in your view, may that have on downstream ecology and environment that is sort of adapted to the current situation? Is there likely to be an adverse effect there, or is it a matter of it eventually finding its equilibrium?
Well, that's a hard one for me to answer, sort of with a lack of information. I don't know, haven't sort of been provided too much information around the downstream areas by the applicant. I think definitely it's something that we should take into account, but I don't think it's something that should prevent us from finding a good fish passage solution either. Potentially we need to get some terrestrial ecologists involved. Yeah, but in terms of, and again, I would like to talk to, you know, the terrestrial ecologists, have a look at the site and so forth. But I'm assuming, yeah, that there could be habitat then gained upstream of the gates. So you probably need to balance that between the two. But yeah, I don't think it should stand in the way of providing a good fish passage solution. I think it's just something that we need to be wary of, and you know, for whatever solution is put in place, make sure we take that into consideration. And I think there's a way that we'll be able to balance it.
Yeah, I guess my question is around, if they're removed and not operating, you're back to normal, what impact does it have on that further down? But
Sure,
it's potentially a question.
Yeah, and I mean, those impacts are only going to be felt mainly at those high tide scenarios. It's not going to change the situation at low tide situations.
Yeah. Well, thank you. I did have a lot of specific questions on the evidence, but we're cutting it a bit fine with time, and I think there'll be a stage 2 of this. So I won't ask you any more questions. I'll just see if Mr. West has any questions of clarification.
Just the one, I think. Paragraph 68 of your evidence, you stated that you were did not believe that the mitigation and offsetting was sufficient. Still of that mind?
Yeah, well, I think I'm a little bit confused because in the PDP 2002 report, I believe it was, the mitigation options report, there was significantly more habitat restoration proposed, like quite a lot larger amount proposed. And it also had said that they were working on a 1 to 4 mitigation sort of calculation there. So that's, you know, and so they were working on the appropriate sort of what they considered to be moderate to good inanga habitat upstream of the gates that could be impacted. So looking at the photos that they've actually provided, saying, well, you know, this isn't good inanga spawning habitat, so therefore we haven't counted it in that calculation. In my experience, and I have done a fair bit of inanga spawning work, it looks entirely appropriate for inanga spawning to me. So I feel like they may have maybe underestimated how much appropriate inanga spawning habitat may have been upstream of those gates, and therefore that may have been much greater. And also in the most recent proposals for habitat restoration, they don't seem to have gone for that 1 to 5 calculation. And yeah, just sort of, I think what they're only sort of offering maybe 1 hectare now, where I think in the original 2022 PDP report, they're proposing like 6.9 hectares, plus I think 12 hectares somewhere else. And then there was a very large amount of coastal wetland restoration as well, but I believe that may have been more passive restoration.
Thank you.
Okay, thank you very much, Ms. Bowen. I think we'll be hearing from you in the future, so thank you.
Right. You're welcome. And can I just clarify, there won't be any more questions today, because if so, I'll take my leave.
No,
and
you're free to go. Thank you.
Great. Thank you very much. I wish you all the best for the rest of the hearing.
Thank you. To you, Mr. Pemberton.
Thank you, Commissioner, and this year final witness for Doc is Ms. Sycamore.
Thank you. My name is Ashley Sycamore. I am providing planning evidence for the notified reasons consent in the submission by the Director General of Conservation for the Titiroa River Tide Gates and associated infrastructure. The following is intended to be a summary of my planning evidence with one small tweak in response to the applicant's proposal for a 10-year consent term rather than 15 years as originally proposed. The current application was publicly notified in August 2023, and the Director General submitted a proposition citing several concerns. These included insufficient information on the effects of the tide gates on Indigenous freshwater species and the lack of consideration for alternatives that might mitigate these effects. I agree that the activity status of the application is a discretionary activity overall. The applicant now seeks a 10-year consent term, but if the decision is to approve, a consent duration of no more than 5 years would be more appropriate from my perspective when considering policy 40 of the proposed Southland Water and Land Plan, along with detailed conditions for monitoring and maintenance. In terms of the statutory framework, I found the application inconsistent with some aspects of the relevant planning documents, particularly concerning the effects on fish passage and e-nail spawning. In my opinion, the application also fails to align with some provisions of the NPSFM and Policy 11 of the NZCPS. The relevant provisions of the Southland RPS and the RCP for Southland have also not been fully addressed by the application, in my opinion. I have considered there is insufficient information to assess the application's alignment with several policies, including those related to the protection of habitats important for recreational and cultural purposes. Lastly, section 104(6) of the RMA allows for the application to be declined due to inadequate information. Given the gaps in the information provided, this option should be considered, or the hearing adjourned to gather the necessary information and allow submissions to respond. I'm available to assist following today where helpful, for example, either through expert conferencing or reviewing and providing planning comments in response to the information.
Thank you, Ms. Sycamore. You'll be pleased to know I don't have a lot of questions for you because your evidence is very clear. I guess it's these avoid policies in the higher order documents, and we do have lower order documents that seek to protect lawfully established infrastructure and those, and while it's a conflict at different levels, Mr. Pemberton suggests, well, policy 11 trumps. I'm assuming that's where sort of your evidence heads.
Yes.
It has to be avoided in those lower order documents that may have a directive approach in another sense. That competing directive approach isn't in those higher order documents, so I'm stuck with in this context, it's policy 11 of the New Zealand Coastal Policy Statement. Yeah. Okay. No, thank you for your evidence, but I'll just see if Mr. West had any questions or clarification. No, no, thank you. You got off the hook there. So.
Thank you. I came all the way from Hamilton too.
Oh, did you? Yeah. Oh, well, it's not to say your evidence wasn't useful or helpful. It's just that it was clear. So, which is good.
Of course, after.
Yeah.
I suspect there'll be more.
Yeah, I think you will be. So it's probably when the rubber will hit the road, actually, rather than now. Yeah.
Thank you.
So thank you. So that's your case, Mr. Deacon. Thank you. Yeah, thank you very much. I think we'll carry on with Taonara. Ms. Blair?
Should we check with some of the individuals?
Yeah. Yeah, I'll do. Where is my list? Is Mr. Holmes here? Afternoon, Mr. Holmes. I'm just checking to see whether you have any time constraints, because we are running a bit behind. Sure, maybe come up here, maybe. Oh, I just missed it, just in the corner there. I'm not calling you to speak to your evidence yet, Mr. Holmes. I'm just seeing whether you have any time constraints.
No time restrictions.
Okay, so maybe we'll leave Mr. Holmes up there if you guys are okay with that. So Ms. Blair, are you running the case or Mr. Fanger?
If it pleases, Commissioner Hubert, I'd like to start off with Mickey and then an overarching summary from me, and then more detail from Mrs. Blair. And then what, from the cultural evidence side of things, and then Mrs. Ferguson around some of that planning evidence. So you're okay with that?
Yes.
Hi. E tautuk te mihi o tātou ki a tātou, ki rogi i tēnei kaupapa. E kaupapa whakahirihira o tō tātou wahi motuhake ara po te titiro. Nā reira, ka tika huri whakaaro ki tō tātou rangatira, kua hinga e tēnei wā. A kingi tūheitia, aroha ki te whānau o tainui i tēnei wā, haere oki oki ai. Huri ki a tātou, te honga ora, kua whai tēnei kaupapa mō mātou mō ngā huri ake nei. Reira, te tonga tai au, ni hau tūki a koutou, o koutou mahi ti ake manaki whenua, ara te papa atawhai hoki, nā kai pamu, ni hau tūki a koutou hoki. Reira, te mihi nui o te rā nei ki a koe Commissioner Cooper, tēnā koe, tēnā tātou. Just firstly, we would just like to acknowledge our enduring relationship with Environment Southland, and that the significant amount of work that we do together in terms of our environment, in terms of our communities right across Murihiku. So, you know, we tend to work very closely, but there are some times when we separate on direction. And this is just one of those cases where we're just not quite falling into line at the moment. Titiroa, as it was and as it is today, is a very important place for us. It has been a crossroads in terms of our travels in the past, a place where villages were set up, and a place where a significant amount of food was resourced from the area and the surrounding areas. Mahinga kai is one of the values that we talk about quite significantly in our summary of evidence, and within our Naitaha Settlement Act, Mahinga kai is talked about as the 9th tall tree. The other 8 are based around land areas, but Mahinga kai really is about, we look at it as an indicator of the health and abundance. Its health and abundance is an indicator of the health of our environment and our people. Other major values that we talk about are ki uta ki tai, from the top to the bottom, and from the bottom of the top of a catchment. And so things that we do at the bottom of a catchment in our philosophy also represents, also has an impact on higher up the catchment. So meaning that we all have to do things together to ensure that our kaitiaki or our responsibility to guard as guardians of our whenua, as people, are undertaken. The gates are part of an older philosophy where some land was termed wasteland and needed to be developed. That's a 100-year-old philosophy, and it's probably not. We believe it's not a philosophy that is a present or going into the future philosophy. 1980s has been talked about as a big time when the area was drained for farming purposes, and we acknowledge that it's significant amount of input put into that and investment, but you know, there are some conversations whether that was the right thing to do it in that particular time. We talk about social and economic outcomes of the present use. That the present use provides both social and economic outcomes, but there are, however, other ways to provide social and economic outcomes and the potential area. And within our submission, we talk about repurposing opportunities. And these repurposing opportunities, they do not exclude farming in our thinking, but we do believe that there has to be a future that's different than the present, and we don't believe a business as usual approach is going to support the aspirations and responsibilities of iwi as kaitiaki and to look after our whenua, especially in the present environmental challenges that we have around climate change and loss of biodiversity and those sorts of values. There was talk within some of the applicants' evidence that they're already undertaking biodiversity, bush and wetlands mitigation. We do see some of that happening in the present system, but it's not a wet system. It's not a traditional system of being wet on the floodplains, in our belief. But what we have seen over a period of time, and I'm not as close to the area, Steve, I'm a bluffy, but the loss of biodiversity over time, including a significant amount of carrick sector being lost about 10 to 15 years ago from the floodplains, which was identified to me by one of our whānau who was quite sad and mamai about the whole situation. So yeah, there has been, in our opinion, more loss of biodiversity over time in the recent time than present. So yeah, again, climate change is something to think about. There's a large amount of work going on around regional councils, iwi, in our nation around resilience and adaptation around climate change, especially in the coastal and floodplain areas. So definitely talked about by everybody. And there's also conversations happening and evidence being produced today about the robustness, there being a robustness within the systems at the moment. In terms of whitebait, functioning of the streams and biodiversity, what's interesting to us is what sort of baseline is that robustness based on? Because past evidence and stories would suggest that some of those indicated species like whitebait have been a lot more numerous and abundant than what they presently are, although one would acknowledge that the titiro is seen as, and Mataura is seen as the go-to whitebaiting rivers. Having said that, we base our thinking on a maramataka, and as Mr. Gardner in his evidence talked about that, you're looking at the cycles of your system, of the tides, etc., of the rainfall. We acknowledge that, but we're of the understanding that in the autumn, the whitebaiting spawning requires flooding for some species from the spring tides, and that would have meant that the flooding or the spring tides would have pushed up further into some of those more natural riparian margins and habitat to provide more abundance or spawning habitat. There is talk about a mitigation package that will lead to enhancement. So we haven't quite got our head around that, but it's just a wee summation on myself and Ms. Blair's evidence. I might wish to pass it over to her. And then, thank you.
So I was just going to go over a little bit of the process that we've had with the consent and then the information that's come in and some of the potential questions I can see coming our way this morning. So like Dean said, we appreciate our relationship that we have with Environment Southland, and I tend to agree with maybe what the council for the council said in his opening submissions around maybe talking past each other a little bit in the last couple of years with us putting things forward in that. I guess for us with our process that's been happening, we've gone to a few hui and wrote a couple of memos around information needs and requirements and things like that, which were around quantifying the need, the functional need of the activity and what area is affected by it, as well as stuff on fish passage and a few other things as well. So we kind of got to the point where I felt a little bit repetitive, so we kind of, I guess that's where we've come to now, that we're now at hearing. So the information that came in yesterday, and I just think it's been acknowledged by yourselves and by the department as well, that it's pretty late. So I guess the way that we work with the Runanga is that when we provided our evidence and wrote our evidence suite, and it's based on direction from them, and therefore that's what that's for. So we probably look at what Doc was proposing around being able to go away and provide some sort of written feedback, because we're not the decision makers, we're here just doing what we're told. And I think before as well it was mentioned around the ecological conferencing that'll happen, and obviously Mark will be part of the panel stuff, but I'd really like to be part of the ecological stuff for around the Mataranga Māori things that come in like that. This morning there was a conversation a little bit around statutory acknowledgements. So they came, obviously they're in their Right Claim Settlement Act, and where they come, what they are there to do is to show council that they are required to engage, or applicants as well, that they are required to engage with us with the resource consents for those. And through time, they have been now incorporated into the regional plans. However, I'm aware that from our point of view, when we see an application that's going to affect our values, that may give rise to a higher order in terms of effects and things like that. But I'm not positive that because it's in a statutory acknowledgement area, it goes the other way, if you what you were saying this morning. But from our point of view, it definitely does. That was pretty, and I just like to, Ms. Drummond this morning talked about the kanakana and maybe being able to change to be able to accommodate them getting over that lip of the weir. We've already done some mahi on that on other areas, so there's information already on that around what they need to be able to get over those sorts of things. And I guess in terms of our evidence, I guess we're still probably in the same position that we were when we wrote this. The information that's come through by Doc, I feel like there's quite a bit more detail that needs to come into that for us to be able to assess it, and I don't think that change in the information that's come in, we've got that yet. So I guess our position is still the same, that we consider the effects on our frameworks and values to be significant, particularly around Kite Kitai, Rangatiratanga, Māori and Mahinga Kai species. But
thank you. I guess what you just said then, Ms. Blair, is that there's possibly another step in that thing or process going from here. I was thinking of you responding to what you've got yesterday and today, and then joint witnessing and then back. I think you all suggested, well, we're not quite there with the information yet, which is largely what Doc suggested as well. There's holes there from your perspective.
yeah, I think that we probably need to have a little more details, particularly on that. I'm not a ecologist, I just know things that I go about things that I go and do, right? That's what I guess. So to be able to look at that letterbox, Flatgate would have to actually look into that and provide some
how it works and stuff.
things like that, and what else is being proposed.
There's a step back though too, I think, from your perspective, is the functional need question. Does it need? I would take it from you that you're still not quite convinced that you have enough information to determine whether it's needed.
Yeah, definitely. I think it's potentially more. I'm still a little bit confused with the model. I'm not a model person, so that could, I don't know if that's, but I feel like there's maybe the limitations that are within the model as it's been put forward. Maybe there could be some more around functional need.
I guess we need to go further back because Interesting what you said, Mr. Whanga, around, and you're right, the old philosophy, the new philosophy, and I think Te Mano Te Wai's take us in a new direction. Because originally, I think you guys signed off on the 2015 consent. I think was that largely on the basis of what had been agreed with DOC about how it would be a 5-year consent and you'd do these things so we could assess it then. Is that?
That was a question we were asking ourselves before too, that we must have been involved because our names in the consent conditions.
Yeah, I can't remember who was working for Tally back in those days.
I don't know if I was on board there or not, but
Yeah, so, well, I guess though what you're saying, things have moved on and what used to be done, it's not necessarily that good nowadays, really.
I think it was back then, if we, it wasn't a case of, well, let's work together to try and get something, but there's a lot of wood gone under the,
well, not
a terrible analogy, a lot of wood gone under the bridge. But we are, I don't think from our perspective, it can't be business as usual. What can we do going forward to look at potential options?
Yes, I'm used to having planning evidence from you, Ms. Blair, more than sort of the cultural, well, even though you provide cultural, you do provide planning evidence, but I'm interested in the Maori of this particular water body. As we know, each water body has its own Maori. What is it particularly about this water body? And then the next question is that, and Doc raised the issue of the health of the water body. Whatever values those this water body has in that context, does it necessarily exclude human use of the resource or the land behind it? You sort of understand what I'm saying?
Yeah, I don't think it excludes human use. I just think it has to be done appropriately.
Yeah.
Which I think that's where the effects on Māori come into it. That's its life force. And the headwaters are being diverted away into another catchment, and then you're, and then what's coming through the catchment is either held up or like it's all just being tutued with, really.
Well, I was going to ask you about that because you have that modification at the top, taking it straight into the Mataura, which isn't part of this, but it's a part of that wider scheme that's sort of at the heart of all this. This is one aspect of it. Yeah. So bearing that in mind, if mitigation measures like this mailbox thing and the kanakana have been able to get over and all that, if they could be dealt with, does it lessen your concern around the impact on Maori? And
I don't know if I can answer that today.
It would be difficult to see in 10 years' time that if we haven't done something about the ability to allow some of that land to get wetter. Very difficult because there's opportunities that might exist, economic, social opportunity that may exist around moving forward into repurposing land and stuff like that. So you wouldn't want it to stay the same, and in 10 years' time, that people are actually thinking that there's other opportunities, including farming around that, but other models that might be available. So, if we were to just change a little bit of mitigation there, but I'm not seeing that it's going to do a lot around the values that we're trying to protect at this stage.
Okay, thank you. Any questions or clarification, Mr. West?
No, address as we went through along. So.
Yep. Well, thank you very much. Ms. Ferguson.
You would have hopefully read my evidence, so I won't go through that, but just pulled out a couple of key points and maybe a couple of clarify a couple of questions that I heard today. Stevie touched on, and I'll just add a little layer on it. So basically my evidence supports the position of Mana Whenua, which is quite a strong opposition to the proposal as is current. And so the outcome sought is the removal of the gates and return to the normal tidal flow. You've heard and read that there's the cultural values, the effect of the proposal on the cultural values is significant. And thank you for acknowledging that today. It's really important. The statutory acknowledgement area, so just touching on that a little further. So that legally acknowledges Ngāi Tahu's relationship with the area, and it's inextricably linked to demonstrating the effects of the proposal as being significant. So how that hooks into Te Tangi is that Te Tangi then becomes that further expression and guidance of that relationship that Mana Whenua have with the area, and it expresses how those effects can maybe be addressed. So in terms of, is that a very important document? Yes, it is. It has significant weight, and as does the fact that the activities occurring in and around statutory acknowledgement areas. Te Tangi is to be had regard to, which I think Mr. McSorley noted. In terms of in the Act, but when you're thinking about your initial question right at the beginning about what is the existing environment and the effects on the existing environment, whilst you have regard to Te Tangi, the fact is that iwi and their relationships with the area are part of that existing environment, past, present and future. So again, very, very important. We've touched on, as have many people today, about is there that functional need, and which is a valid question, as is it a regionally significant infrastructure? Those are questions that I had myself. Overall, I think the general opinion was just that sort of lack of information, but sounds like we're going to be getting some more, which will be fantastic. That sort of absence of information has, in order for us to be able to understand if the concerns that we have can be addressed, and that we can change that position to feeling that the impact is not significant. I don't think that's necessarily the case, and therefore my planning, I guess my opinion is that to maintain that avoidance direction until proven otherwise.
Okay, thank you. You touched on the environment, and you might have heard the question or the discussion around the environment that was created when these things were legal. So there was an environment created then that created it was created as a permitted activity, I guess. In your view, is that part of the legal environment still now? So that dryish pasture, as opposed to what possibly was there pre-1900s?
I think professionally the existing environment is without the structures.
So that would be the developed pasture getting wetter.
Correct.
Yeah.
And that's also, yeah.
It's probably the effect of removing this. Yeah. It's so complicated, this in terms of the legal situation. Yeah. That functional need question too, though. I don't think there's any question about that it's a tide gate, so it's probably going to be in a coastal area anyway. I think we're talking about coastal marine though. But surely I'd have to first make the decision that it's actually needed, or appropriate. Probably is more of a question, not needed, appropriate, given some of the concerns raised by submitters. It just may be a case, well, it's not appropriate. So if it is appropriate, then obviously it's going to have a functional need to be in the tidal zone. But I don't know, moving it further up the river, technically be outside the coastal marine, given how that's defined in the plan, but it'd still be in the coastal environment, wouldn't it?
And I think from, jumping in time, Manawhenua perspective, that boundary of jumping from the CMA over into the non-CMA is irrelevant, because if you shift it up, you're doing the exact same thing. You're just moving the problem upstream. But it may tick a box legally to be there, but the effects on Manawhenua's values would not change.
I was interested in your arguments around reclamation, and Thompson didn't actually address that, but it may be something that we'll consider later.
And that's, I think, maybe, yeah, is that part of trying to determine that existing environment, because if the land has actually been reclaimed.
That's what was like going through my mind. It's like, how does all this interact? Yeah. What's the 11th? Just needing to check a policy. There's policy in your evidence, policy 11.2.1, suggests it would direct the activity not occur, which is the regional coastal plan. I have a note there saying, well, that's qualified as wherever practicable.
Sorry, what was there?
So it's your paragraph 1146. This coast plan is quite hard to scroll through. Yeah, it's the avoid wherever practicable the effects associated with the present and construction of new structures and extensions of existing. So see, that talks about existing structures in the coastal marine. You would read that existing structures in the context of it being legally existing.
Oh, sorry, I haven't got the policy wording in front of me. Yes, it would have to be illegally or lawfully.
Yeah, well, that was my next question, because these policy documents, they flick between them. Lawfully established is not the same as legally existing. And I find it not necessarily having been involved in writing plans. Well, the courts will say, oh, well, that would be deliberate. And I can tell them that it wouldn't be deliberate. It would just be an oversight. So I'm just trying to get grips to what actually is meant in the context of some of these policies. Yeah. Now, again, your evidence is very clear, and I expect probably to hear from you again. So I'm going to leave my questions there to see if there's any clarification from you, Mr. West.
Very briefly, at the end of your evidence, you state that you don't consider the applicant's been able to mitigate or remedy all adverse effects satisfactorily. Having heard the evidence presented today, are you still there?
Until we've been on back to whānau or had further information on you.
Thank you.
Okay, thank you very much. Was there anything else you just wanted to highlight, or no?
No, thanks.
Thank you. I'm wondering, maybe we take a short break now for 10 minutes, then come back with Mr. Morton and Mr. Holmes. So maybe if we adjourn to 3:10.
What parts I can understand and I have here.
Hey, well, you're in the same boat, because as you probably worked out, we're all kind of struggling with. It seems strange to the lay people I know, but there's an existing environment you can see, but there's a legal one under all that guff. And trying to work that out is quite difficult. So welcome along, and well, it's gone. Before you start, I wouldn't mind you showing me, I see that is land that you own.
Yeah.
And I just wonder if there's more.
Over here. This is mine here.
I had a feeling when I drove along Fleming Road, north of Fleming Road, I thought I saw your name on a mailbox.
Yeah, you would.
Yeah.
Yeah, as you come across the Matera Bridge.
Yeah.
You turn down Fleming Road, and then you got a first pump shed, a second pump shed. The second pump shed is my start beyond the bottom. Yeah. And that drops down 2 paddocks to the Tittaroa River that goes through here, as you can see. And those paddocks here are all my paddocks, and this stuff down in the bottom area, the rough block at the back. So yeah, and I've got a bit of hill country up around the top here.
Yeah, okay.
And that's,
so is that okay, good. So that plan there that shows the known drains, have you got drains on your property? Because
yeah, we've got open drains, and we've got drains and shutters on them, the culvert drains with those steel traps. And that's, so we got along here, we've got a lot of the open drains, just on the Tittaroa down the bottom here and down right on the bottom block, right here. And if there was high tides, they would just push the water all back up through there into the land. And I mean, those land blocks are already wet, you know, even though you've drained them, they're wet blocks in the winter. And we've had a lot of rain lately, haven't we, Liz? And I mean, yeah, it's not good.
I saw that yesterday, that's why I wondered how much rain you'd had, because it did appear.
Yeah, some of it's sitting around in the paddocks.
Yeah.
You know, like ponds and that, which like Lee said, he's done open drainage all down through his blocks here. You know, and I mean, you've got where they can push the water back up onto the top of the ground there. And that's, so yeah. That block, when I was a kid, this block that Lee's is cleared off. When I was a kid, that was totally gorse and scrub. So I mean, you couldn't see through there. And all that now is beautiful farmland. So I mean, but then again, there's a lot of blocks been cleared for farmland that was scrubbed.
So how long have you owned your?
My father had it for 63 years.
Oh,
and
so you have quite a history.
Yeah, and I've been running it for 7 years now since my father passed.
Yeah. Okay. Yeah. Well, that's useful because you'll have an insight very similar to Mr. Frisbee.
Yeah.
So you got some notes?
Oh, I've just got my submission. If you want me to read that out, or
I
don't have to read it out. I can just talk to you on the subject if you want.
You just talk to me because you've heard a lot today, probably.
Yeah.
So the value of you being here for me is to hear what's been spoken about and give me some examples of how things work or don't work, or how you see it panning out. Because these things, hearing from the locals in these scenarios is very important. Because no offence to the experts over here, because quite often you'll know how it works. In theory, sometimes it's different to the theory.
Mm-hmm. Well, since I've taken over the proper, I've fully fenced the creeks and the river, and on the high tides, if the gates have been left open down there for any reason, I don't know whether they're working on them or what, but that'll cover those hot wires. So then you spend the next day having to clean off the weed, everything, you know, otherwise your hot wires are down. And that which makes it a hell of a job, you know, because I'm a one-man farmer. And I mean, at the end of the day, the other floods will do the same. They cover all your wiring, everything. So you're out there like clean them off for days on end, don't you? Taking the rubbish and that off, toppings that other farmers have topped off, and because of the flooding, sweeps it down, and it'll take your fence with it. You know, we had a flood there last year where the bales, someone left bales out. You know, you've got to put bales out now and break feed before the winter. And they come down, they just sit on the barb fences that we have got, and they'll spin and spin with the weight, and then they'll take the fence and everything with them once they're finished, you know.
So are you talking upstream catchment flood or?
Yeah, well, no, that's upstream I'm talking about. But the first one I was talking about was when, you know, the wires along the Titara, and I put along there, keeping stock out of the Titara and off the Titara. Now the water, when those gates have been left open, the water comes in and all the weed sits on the wiring, you know. So you spend a day, like I've got 3.7 Ks from one end of my place to the other on that Titara. So you're spending another day going down one side, then back up the other side, taking all that rubbish off your fence to get your fence back up and going.
So how far are your fences back off the creek bed?
Well, we've got them about as well as a metre, isn't it?
About
About 3 metres. So, yeah, well, I hired Mr. Frisbee to come in and help me when we put them up. So, yeah.
So how often has that happened? Gates have been left open and that's happened?
Not that often, but if they have been or anything like that, you know, like that's what I've found. That you go out, the river's right up, it's over your bottom wiring, you know, and it's just covered the weed and crap and sticks.
And how far does it inundate your actual paddocks?
Well, it comes in the back block and along my bottom block there. On a thing like that, it can come in by 3 or 4 metres. So that blocks me access to get my stock off my flat up onto the higher ground.
Yeah.
You know, like if you get a flood and you can't get onto the embankment, you know, like you're buggered. You've got stock that unless you get out the other way.
Yeah, and the water table, you'll notice.
Yeah. Oh, with when they're open, the ground's just like porridge. You know, like it's not good. And that's so it's one of those things. You know, like you couldn't farm it without them. I don't reckon anyhow. But I'm going by what my father told me, and as well, you know, he always said, don't ever let them get rid of those locks. You know, so he knew 63 years of farming a flooding property, which can be very stressful. And I mean, we wouldn't only have floods coming one way, we'd have them coming another way, which, you know.
So your property is quite long.
Yeah.
So I'm assuming the bottom bit is the most affected. What happens up your Fleming Road end? Is it as bad there or is it still?
Well, it is in places. I mean, like if you drove around there the other day, and I know where you've probably seen the water, and that's the next block up from me on Fleming Road.
Yeah.
And that's TV's block. And I mean, yeah, and the rain the other night, I got up in the morning and I looked out my window and I thought we'd actually had a spill. But it was just the puddling, you know, that had come in through the waterway, you know, like out through the ground, you know, because you've got probably about 2 foot of, you know, solid soil down there. And then after that, you're hitting clay. And that's so, you know, like that top bit gets wet.
Yeah.
You know what's happening there, don't you?
Yeah.
Yeah.
Yeah. Well, thanks for that oversight. I'll let you talk to your notes.
Yeah. And I was going to say about the whitebait and the eels and the fish. I've got a grandson I'll bring up in that, and there's a lot of his mates come out and they go fishing down the Titara quite regularly, and they've never had a problem without, you know, bringing trout back like that, you know, and perch, you know, decent sized perch, and then out of the river. And you know, most times in the year you'll see whitebait flowing through that river, you know. And for eels, I let a commercial eeler in 2 years ago, and he eeled that part of mine. And it was about 2 ute loads every day he took out of there. And so there's a lot of eels in that Titara.
So this is all above the bridge, obviously.
It's all above
the gates.
all above the locks. And what I was going to say about eels is a lot of eels will cross land. If they want water, they'll actually get out of the waterways and they'll cross grass till it's wet.
Yeah.
Now, you might have struck an eel on a hot sunny day after the morning cleared and he's dead in the middle of a paddock. So he might have been going 3K to head down to another river, but he's never made it because of the sun getting out. You know what I'm saying?
Yeah.
So they do. They will come out of waterways and go around it and go back in. I've seen them do it and that, but
trout don't do that. No?
Oh, trout don't do that. But I mean, the size of the trout, the grandson that are catching in the river, and I mean, even if you look in the water on a good day and you see the wee baby perches going through, you know, and stuff like that, and we trout. So I mean, there is plenty of fish in the Titara, considering if I look back when I was a young fella, you know, I don't think there was as much fish, but you still had the whitebait going through as much as it was.
So so did you say that there's not as much fish?
No, there is now. Yeah.
Yeah.
No, there's plenty of fish in there now.
Because I was going to ask you about that, the fishery, because the Fish and Game have a submission in against this, obviously, but I think the submission did talk about it being a productive fishery. So you do actually have people fishing the Tirarai, do you?
Yeah, we have people walk down the Tirarai and fish, town fellas and that, come down and fish along the river and that.
And is there easy access to it? Or do they have to talk to
On
you?
the opposite side to what they're meant to be on, yeah, there's easy
Right.
access. But if they're on the side they're meant to be on, no, there wouldn't be. Because there's bush blocks and all that along that Tirarai. So, yeah. But I don't mind as long as they're not doing anything, wrong.
Yeah.
If they want to have a fish along the river, good.
So anything else you
Well,
there? I think we probably covered most of your.
Yeah.
So your father, he would have been there when the gates went there for some period. So did he ever talk about the impact on your farm then?
Yeah, well, even when we're kids, like, he'd go on about the locks and that, and the importance of having them, and that, and it's like the other floods from the other end. You tell us a lot about that and then that. So, well, the thing I've got to say, since I've been back, because all the flood banks and that are all up now and that where they never used to be when I was a kid, and a flood could come just like that, whoosh, from the other end, and now you can have that pull up, and it's going to come over by your readings, and you've got an hour and a half still to get your stock off, which is good. Yeah.
Right. Anything else you want to add?
Well, not really. No. That's all I wanted to add was just that everything is pretty much the fisheries going through there, and that to me looks as good as gold. And it's just without them, I know my property would be virtually a waste of time farming it because of the wetness. Yeah. No, thank you very much.
Thank you very much for your time and effort and sitting through this today. I know it's not that exciting sometimes, but thank you very much, Mr. Morgan. So that takes us to you, Mr. Holmes. So I have read your submission as well. And you seem to have a different position to Mr. Morton, so I'm in your hands and here to listen to your submission. Yep. You don't have to read the one that you've already presented. I've read all that. If you just want to highlight some things about you've heard today.
You want to show them on the map?
I read the submission, I put the total submission I put in.
You don't have to read that whole thing. You can just pick.
Wouldn't take long anyway.
Okay, well, we've got time today, so just before you do that, maybe Mr. West could show.
I'll show you.
Yeah. So I think you did it earlier,
Yeah,
but just for clarification, just where your farm is.
Okay.
It's all this piece here. Right up to that line there.
I think I may have driven up your road a little beyond the gates, and you drive up the hill and had a look back. Would that be right?
Yeah.
Excuse me, Les, could you point out the junction block for us, thanks? That's where the Titara and the Waimaheka combine.
The Waimaheka comes in just there. That's the Waimaheka stream goes.
Coming into the Titara.
Yeah. Waimaheka stream comes down here and then round that bit of bush there and comes out, and the Waimaheka joins onto the Titara right there.
Yeah, thanks, Les.
Yeah. Thank you.
Right. The Holmes family have farmed a 900-acre property known as Waimaheka and have done so over 5 generations of ownership for 149 years. Their property is the largest privately owned affected by this scheme. Having lived beside these 2 rivers all my life, I have a vast practical knowledge of them. Just some points of interest here. 1, the Titara tide gates and the locks are the same thing. 2, my reference to the Titara and Waimaheka rivers are the parts of these rivers from above the tide gates to the upper reaches of the original tide zone. 3, the Catchment Board and Environment Southland are the same identity. Many years ago, I was talking to a local identity about the old locks that were built just after World War One. He told me they were never successful, built of hardware with top hinge gates. They were prone to blockage by rafts of weed and logs from floods. They fell into a state of repair. I was approached by a catchment board employee, informing me that they were going to build a new set of tide gates in 1986. I disagreed with the whole concept, informing him a better idea would be for landowners affected by the tides to build maybe 1 metre high tide banks on the lower parts of their rivers and install steel flapper gates on the drains that feed into these rivers. This idea was ignored. This system would not have affected these rivers like the tide gates have. These rivers were alive with fish pre-tide gates, mainly cockapoo, which is Mary trout, shrimp, whitebait, smelt, long fin eel, short fin eel, flounder, kura, yellow-eyed mullet, brown trout, lamprey, perch. All these species have been caught by me in these rivers, pre-tide gates. I have observed whitebait spawning in one of my drains that feed into the Waimahaga River, approximately 1.5 miles upriver from the tide gates in March pre-tide gates time. I've got a small note in here, commercial reading should also be banned in these rivers. There's a large shag rookery in the Matais on the Waimahaga River. At nesting time, they used to source their feed for the young in this area. Now you see them having to fly to the Matara River, Waituna Lagoon, Fort Rose Estuary to feed their young. Since the tide gates were installed, water quality has deteriorated. It's become more brackish, almost semi-stagnant. With the flood and ebb tides flashing the rivers, this water was kept free. Also, there's a serious silting problem in these rivers because there's no flushing effect. Environment Southland, this situation is a total disaster and I hold you totally responsible for it. I recommend you get your own house in order and set an example to farmers who have been penalised by the winter grazing regime. Just another factor I've got to bring up here. In 1968, my father and I decided that we would start swamp development. We had the machinery to do it, so I went down and I ploughed 14 acres in the junction block. That's the block Claire Frisbee just pointed out on the map there. This was done before the Titiroa tide gates were even thought of. This block we classed as one of the lower blocks on our swamp. It should also be noted that the old tide gates were totally non-functional at this time. Another factor is this was done in January and February when the autumn moon tides were starting to take effect. That's my submission.
Thank you, Mr. Holmes. Just in relation to that last point, were you bringing that up because you could develop it?
In 1968, that land, my father and I walked over it. We decided it was developable.
Yeah.
It had all been ditched. And we came to the conclusion that we would start on the junction block, which is the lowest block in the river.
So that was without tide gates operating in it?
It was with the old tide gates non-existent and with, well, the new tide gates didn't come until 1986.
Yeah.
This is 1968.
And
we saw no problem with tidal streams coming up into our land. Hell, if we had tidal streams and what's been described to me over these submissions, we would never embarked on this project. We put a lot of homework in before we decided to develop. A lot of homework. And also we know this country.
okay, thank you. And we talk about your suggestion back in 1986, the 1 metre high tide banks. Same sort of idea, I guess. You thought that they would work because there was no groundwater issue?
On the lower banks, the Titterroa River's got a series of high banks where the tides don't affect it. And then there might be a drop down into a lower area. Well, put a metre or a metre, it might be up to 2 metres levy in that lower area. And then all the creeks or ditches are running out into the Titterroa, put steel fabricates out, problem solved. And it could be done for a fraction of the cost of what the locks cost. Well, I was against those locks. I wanted to have a bar of the damn things. In the end, I was fronted up in 1986 when I just bought the farm. And I had to pay $2,000 towards those locks, which was
A lot of money in those days.
a hell of a lot of money. And there was no money around for me in those days either, but I had to front up and do it.
Okay, well, thank you very much, Mr. Holmes, for your perspective on the whole deal.
Thank you.
And again, thank you for giving up your afternoon coming along. So,
Well, it's the thing I had to do because I wanted to do this.
thank you very much.
Thank you.
I think that brings us to the end of submitters. It's more a question of where to now, Mr. Thompson. Normal process, we would hear from Mr. West, but given the dialogue and I would say almost general agreement that there needs to be another step here in terms of allowing some response to the latest evidence and joint witnessing, and then a reconvening later so then the normal hearing in could occur. Dare I say it, Christmas is coming up. Well, it's September soon. It's just trying to fit all this in. So I'm going to adjourn, obviously, but my question really, probably for Mr. West and yourself, I'd probably be interested in hearing from the parties on what you think should be joint conferenced on, because there's a hell of a lot of information.
Yeah, and I think I've been rolling that around in my head today, and there's, we've got. I think we need to be a little bit careful that we constrain expert conferencing to things that are actually going to really help you out.
Yeah.
Because otherwise we could go in all sorts of directions and people giving all sorts of opinions on things that are either not helpful or wrong. Yeah. And so one thing I've been observing, particularly divisions of the Environment Court that Commissioner Jim Hodges sits on and all the water quality stuff, is he actually gives people quite sort of clear direction. Now that can be helpful, but sometimes it can be unhelpful, and sort of takes away the party's role to the way the parties put together. And I'm sort of thinking out loud, by the way, things. My own view, given the discourse today, I think that the first step might be a direction for the applicant to consult with the other parties and file a memorandum with a proposed timetable and steps, just to take it off out of your to-do list. Take it off your to-do list.
Sounds excellent to me.
Quite like that. So we could get into some comms, particularly with Department of Conservation and Runanga, the two parties who have been most vocal on this, but everyone should be entitled to comment on it if they wish.
Fish and Game,
yeah,
they
sure.
make it today, they need to be involved. Sure.
Yeah. Well, that's for them. So I could get a mailing list from Catherine. You could make a direction for us to consult and to determine a list and say, give us, say, 2 weeks to do that, because it could be a bit of to and fro. We then file a memorandum asking for, with luck, directions by consent. Then we go to it. And those processes can proceed. I mean, I'm not sure what other information the other parties are going to want. It might be something that's going to take a while. It may be relatively straightforward. I'm not sure. And it might be that their responses in writing, I mean, my own view is those responses probably best to come after conferencing, because there's no point the parties expressing position on things that the experts agree on. But look, I'm not going to make a fuss about that if that's what others want to do. So that's my suggestion. Just to summarise again, a direction today for the catchment division of the council to liaise with all the other parties on timetabling directions for number one, further info requests, two, subs in writing on amended proposal, three, expert conferencing, including role of Ngā Tauranga Māori experts, which I think is something that's going to have to be thought about a bit.
Yeah.
Matt and I do have some experience with that, though, in a case that he and I were involved, Mr. Pemberton and I were involved in up in Tasman.
You see you both in the same part of the country.
Yeah.
The further information thing. Yeah. I'm thinking aloud. It's just how that might work and without.
Well, I'm not sure yet either, because all I know is the other parties are saying, right, you've provided us with information, but we need more.
Is whether there's a way of dealing with that within a short-term consent process with those things factored into that. But might not suit your client either.
A short-term consent process, sorry.
Well, as a part of the consent conditions, that further information, I'm thinking.
Well, I mean,
might not work either.
Well, the conditions are intended to be drafted to do just that, and to provide for flexibility around figuring out what the right option is. So,
I think we go down this step first, because then that'll bring, number one on that list will bring that out.
Yeah, that's right. And I think we need to go through a process, because that's really the direction that was quite clearly signalled. I mean, it might be that the first step is the other parties state their positions in writing to the amended proposal, and that given your very clear direction on your expectations of the applicant, that a slightly longer time period is given for those submissions in writing, and the applicant, and should the parties have any questions, they go straight to the applicant, and the applicant provides information as best it can. You've been loud and clear on what your expectations are, so I can, without instructions, assure you that my client will be cooperative. If you, when I say without instructions, I will ensure they are cooperative in terms of providing additional information to grease the wheels.
So 1 and 2 change.
1 and 2 change. Well, 1 goes away, because I don't know what 1 looks like, because all I know is that.
That's kind of where I was thinking, that you get the response to the amended proposal, and you just jump in whenever you think appropriate. We'll come back with, because it's quite hard to digest a lot of this technical stuff too in a short time frame.
Yeah.
And they may find, well, actually, some of that information is there.
Yeah.
But if they respond to that, then come back to the response to that and what else they might want to see, the areas where it isn't as clear, and then that will inform how we move down. So
yes,
down the process.
Yes, I mean, look, we are motivated to get this thing moving, and as I say, if an adequate time is given for the response in writing from the other parties to be given, say 3 weeks as opposed to a week or something shorter, that means we can signal, look, if you want, ask us questions and we'll give you information as best we can, and then if we don't satisfy them, they can raise that as information that needs to be addressed in conferencing. But I think the first step is getting agreement to that process, which I can take charge of, and then we can come back to you with some, as I say, some hopefully directions that are sought by consent.
Well, it first requires a minute from me directing you do that. And then next minute we'll whatever you agree, or then put that in place. Yep. You have any comment on that, Mr. West?
I'm happy with the direction of travel. Felt that one of the crucial aspects would be the two ecologists that talk to each other in that sort of conferencing. But yeah, there's other issues as well. One of the crucial things I think I'm looking for from the applicant side of things is just to iron out some of these inconsistent numbers and stuff that have been bandied about.
Yeah. But I think some of that's historical too. It's just like it's just got cool. Yeah.
Things happen.
Yeah. But you can do that in the meantime. Okay, well, I think that's probably the best way to deal with this. So on that basis, we'll adjourn. I'll get a minute out that you parties can respond to. And that next process will probably be largely driven by what comes out of that. Okay. Well, thank you very much for your time and constructive input to your team and to submitters. I think they've all gone. Don't blame them. It's been a long day, even though it's only 3:45. And we've actually wrapped up earlier than Catherine's minute, which is actually quite good. Well done, Catherine. But it has been a useful day. That this is vexed because of that legal situation and how the policies relate to that. So on that note, we'll adjourn and I'll have a minute out early as I can next week.
Very good. Sir.
Okay, thank you. Thanks for your help, Catherine and Mr. West, but your job's not done yet.